require urgent consideration. For those matters which are listed, if we find that there is no urgency, I'm going to impose cost of 50,000 to 1 lakh, because we cannot tolerate contempt matters being moved in the vacation. Yes, one by one.
My lord.
On 4th of December. Request is rejected. Request is rejected. Request is rejected. Yes, next. When was the order passed? When was the order passed? When was the order rejecting the plaint passed? When was it passed? Plaint reject ಆಗಿದೆ. ಯಾವಾಗ ಆರ್ಡರ್ ಆಯಿತು? ಯಾವ ಡೇಟ್ ಹೇಳಿ, ಯಾವ ತಿಂಗಳಲ್ಲಿ ಆಗಿತ್ತು? So then why you didn't move before 20th? Iವಾಗ what is the urgency now? Opening day. You have waited for 10 days. You have waited for 10 days. You wait till the reopening day. Yes, rejected. Next. When was the order passed? Then why you kept quiet so long? Let it come on the reopening day. Yes, next. Just wait, just wait. Yes. Just 1 minute. ನಾವು ಯಾವ್ದು ರಿಜೆಕ್ಟ್ ಅಂತೀವಿ ಮೆಮೊ ಇಸ್ಕೊಂಡು ಅದರಲ್ಲಿ ಎಂಡಾಸ್ಮೆಂಟ್ ಬರಿಬೇಕು, ಇಲ್ಲ ಅಂದ್ರೆ ತಿರ್ಗಾ ಮೂವ್ ಮಾಡ್ತಾರೆ ನೆಕ್ಸ್ಟ್. ಎಸ್. Execution proceedings cannot go on during vacation. You are aware of it, isn't it? So I'll have it on the reopening day. Put it, reopening day. Yes, next. Regarding? What is the inquiry regarding? So we'll have it on the reopening day. That's okay. You participate. Nothing is going to happen. And the court will consider interim relief on the reopening day. List. Date code. Yes. What is the last date? 27th. 6th. Tomorrow. Reopening day. Maybe. Let us. Reopening day. Yes, next.
Power of authority considering the application. This has been issued, matter was advanced, and on the last working day, they tried to dispose of it. We have submitted saying that the matter is pending before this honorable court. they tried to execute it on the last day. Okay, they had moved the matter on the last working day. The matter was ordered to be listed on 27th, not before.
When was the order? It was ordered to be listed on 27th. Tomorrow. Yes.
My lord,
Show cause notice was challenged in the writ petition, my lord,
Show cause notice regarding
regarding my lord, initiation of contingency disqualification proceedings against the petitioner. My lord, writ petition, my lord, was dismissed, with giving liberty, my lord, to go and explain the show cause notice. And my lord, further, my lord, the writ petition, my lord, has been dismissed on the ground of merit also. My lord, the contingency proceedings, my lord, now they are continuing the proceedings.
that's okay. Reopening day. Kodi.
my lord, there is extreme emergency in this matter, my lord. In the farmer's land, the KPTCL is trying to install the power transmissions, my lord. And these lands belongs to the farmers and they're solely dependent on the crops, my lord. Kindly list it.
No, you're challenging which order?
Like they're trying to install in the farmer's land, my lord.
Correct. Now you're challenging which order before the division bench?
It's like it's a fresh matter, my lord. Kindly, due to urgency, kindly list it on.
How are you moving it before the division bench directly? How are you moving it before the division bench directly? No. Yes, next.
My lord.
The matter is listed at serial number 11.
Huh?
Matter is listed at serial number 11.
Yes.
I'm seeking a short accommodation for the office objections compliance. Matter may be posted on 6th.
At request, list the matter on the reopening day in light of urgency pleaded. Time granted for compliance of office objection. No, which 1 minute, just one. This matter. Just wait. Yes. Yes.
Ajay.
Now you have challenged. Yes, tomorrow.
My lords,
Serial number 5, my lord, in list number 1.
Just 1 minute, just 1 minute.
my lords, this is the old matter. The matter has been heard and reserved for orders, and there is an interim stay that has been granted by this court to maintain the status quo. Despite that, the respondent number 2 has issued a notice to acquire the scheduled property in this matter, and they have also trespassed into the land to take the possession and demolish the structures.
Correct,
Hence, there is
madam.
a-
When matters reserved for orders, it would not be appropriate for any other bench to intervene. Now, your urgency can be addressed before the same bench. We can only, if you give the memo, it will be transmitted, because it would be an act of impropriety if we were to pass any order on matters seized off. You give it, we'll transmit it to the appropriate bench. Once adjournment can be list wise, adjournment can be page wise.
Five, my lord.
Yes,
Lord, it could be taken up, my lord, on 8th, my lord. I need some time to complete the office objection. And my lord, the impugned order, my lord, is also passed by,
we
my lord.
list the matter on 8th at request.
And I may be permitted, my lord, to complete the office objection.
Office objections are permitted to be complied with.
Please, great.
List 1. List the matter in the week commencing from. Put week commencing from. Yes. Yes.
Serial number 7, 8, my lord.
Serial number 7, 8,
7 and 8, man.
7,
This is-
8 and 10.
Yes, and not.
7, 8 and 10.
Yes, my lord. These
7, 8
matters,
and-
my lord. Only my humble request is this, my lord.
No, let it come after vacation. No urgency.
Alala, in respect of my lord, pertaining to the site in question, my
No,
lord.
then you wait, it will be called.
Please,
You
my lord.
wait, yes,
Please, my lord, please.
Serial number 14, my lord.
yes.
It's listed for office objection. Kindly have it after this.
Serial number 14, list the matter in the week commencing from. No, but you have to inform the other side. Otherwise, when it reaches, I will see. Because you have to inform the other side. They have moved it, let us see.
Item 32, my lord, at page 6.
32 after vacation.
My lord, immediately, my lord, I'll take instructions insofar as A2 is concerned. But kindly have it, my lord. What has happened is construction is going despite, my lord, an
List
order
the-
of status quo.
Relist the matter on date code, first week. Yes.
Grateful. Great.
Thirty-three. Have you informed your appeal for the respondent? Correct, but unless you have informed the other side, I will not grant it now. When it reaches, you make a mention else. Yes.
My lords, kindly serial number 34, my lord.
Yes.
14% has filed, when I have been directed, I'll take notice for the appellant and I am permitted to appear for the appellants, my lord. ವಕಾಲತ್ತು ಹಾಕಿದೀನಿ, 14% ಹಾಕಿದ್ರು.
So let it come up. I'll permit you. It can come up after vacation. There's no urgency.
ಅಲ್ಲ ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ, ನನ್ನ ಹೆಸರು ತೋರಿಸಿಲ್ಲ, ನಾನು ವಕಾಲತ್ತು ಹಾಕಿದ್ದೀನಿ.
Learned Counsel Shri B.N. Jaideva submits, appearing through video conference, submits. He is instructed to file wakalat. Accordingly, list the matter in the week commencing from. Hello, week commencing. Week. 6th January. 34 to 38, same order.
Same order. Highly obliged, my lord.
Petition is infructuous.
Learned Counsel for the petitioner files a memo. In light, the said memo reads as here and in light of the same, petition is dismissed as having become infructuous. List after vacation. Yes. Let us see. These contempt matters I'm not going to touch. List the matter after winter vacation. Same order.
I am at item 2, my lord. I'm sorry.
Yes, after vacation.
No, my lord, one indulgence, my lord.
Contempt matters I'm not going to hear.
No, I understand, my lord. So far as annexes, my lord, the translation copy is sought for. My lord, they're all copies of the read papers. I may not, my lord, rely on those. My lord. What is
The
to be
office
looked?
objection relating to furnishing of translated copies
Please,
is
please,
kept in abeyance for the present. List the matter after winter vacation.
please. Grateful.
Appear for the petitioner. Let the sale taken place.
After vacation.
But there is some urgency in the matter.
The finding is it's not granted land. It requires hearing. I'll post it on the reopening date.
Let the there is only one question, my lord. Sale after 1179. In spite of the expiry of the non-alienation period, the permission is required. That's a
No, let us
division
see,
bench.
but
That
it's
is a
not-
division bench.
It's not a matter for being dealt with in the vacation. Relist the matter, reopening date for it. 6-1, yes.
Not 328, if your lordship just have a look at one. The order passed by this honorable court.
Now, what have you challenged?
My lord, what had happened is, learned single judge has directed, my lord, initiation of contempt proceedings against, my lord, the Nursing Council of India.
Earlier, I had occasion to consider and pass an order, page 344.
Yes, my lord.
Huh?
Yes,
But
my lord.
you have to undertake that order you will implement.
That order, my lord, we will implement, my lord. Definitely, my lord. Alva. This, my lord, definitely, my lord. And we have done it also.
The senior counsel appearing for the appellant submits that the learned single judge has directed initiation of
Suo motu
suo
contempt.
motu contempt proceedings. Full stop. It is submitted that an earlier interim order in the same proceedings produced at annexure R3 dated 11/6/24 has been adhered to, and if that were to be so, question of initiating contempt proceedings would not arise. Question of
Yes, my lord. Absolutely.
initiating contempt proceeding would not arise. Further submitted that the order dated 11/6/2024 would be complied in letter and spirit.
Yes.
Full stop. In light of said submission, subject to further proceedings, there would be stay of the order dated 12/12/2024 insofar as the direction to initiate suo motu contempt proceedings against the appellant.
Yes.
This is the matter immediately after winter vacation.
Yes.
After winter vacation.
Please.
Mr. Naik, unmute ಮಾಡಿ.
Please, my lord.
Let it come up after. After
My humble
vacation.
request, my lord. The only point is involved, my lord.
No, not during vacation bench. How can we
No,
hear?
because the
Order
point
of restoration is,
the-
order of restoration is. set
by
aside.
virtue of the order of learned single judge, my lord, it is the entire order of the AC and Tahsil, the AC and DC has been quashed. But it is already, my lord, confirmed by the division bench.
Let us see, after vacation, not during
My-
vacation.
ಅಲ್ಲಿ-
Order of restoration is set aside, isn't it?
Yeah, based on, my lord,
then-
the Honorable Supreme Court judgment, Nekkanti Ram Lakshmi.
Let us see,
Which
not
is,
during
my lord,
vacation,
which is,
not
my
during
lord,
vacation bench. Mr.
already restored the
No,
property.
no, let us see. List the matter immediately after winter vacation. 7, 8 and 10.
Please.
Yes.
In a matter where we are just to sought for consideration, the learned single judge comes to the conclusion that that officer had been suspended, and on that basis.
Let us see. It has to come up before the regular bench. You are seeking for extension of time. That
The
requires,
only recommendation is being sought to be considered.
let us, this is the matter on the reopening day. No Passover in vacation bench. Huh.
The tender, my lords.
You have not paid court fee also?
Paid it,
Huh?
paid it. Shall we pass down?
No, no Passover. Could you file for it?
What for the tender notification today?
No, you have been who are you now? You are the earlier person.
For the appellant, my lord.
Huh?
Appellant, my lord.
Correct. Appellant is the earlier.
Is the petitioner.
What is the relief that you have sought? What has happened to the tender process now?
My lords, they have called for the tender notification today, my lords. It shall be passed on, my lords. May be heard on, my lords.
No, they've given you liberty. They've given liberty to pass a fresh order after hearing everybody. How are you aggrieved by that
But
direction?
my lords, order 3 says such, my lords.
No, the award has been, now the tender has been cancelled. Award of tender has been cancelled, isn't it? And then they have granted liberty to the third respondent to pass fresh order after providing hearing to all stakeholders. So the order of cancellation dated 4/12 is set aside. They've only given them liberty to hear and pass fresh order. So how are you aggrieved by this one?
But my lords, order number 3 says that, my lord, the respondent is at liberty to pass an appropriate order, my lords, in fresh accordance with law.
Correct, correct.
But my lords, the
That only
appellant,
after, now you go and avail of that opportunity. In case they agree with you, they may decide to close it.
but my lords, this contract was for 5 years, my lords.
That will see.
Fine.
Let it come in the reopening day.
My lords, it may be passed over, my lords.
No. Release the matter on
Lords, But
reopening
they
day.
have called for the tender notification
That's
today, my lords.
okay.
He has invested so much of money.
No, that we'll see.
Around 50 lakhs, my lords.
No, that we'll see.
It shall be passed over, my lords.
No. Release the matter, reopening the date.
Serial number 13, I appear for the appellant's counsel. The only urgency is this one. There was an order of attachment which was stayed during the pendency of the writ petition. Now, the only error, my lords, I would respectfully submit the learned single judge has committed is my prayers in the writ petition were threefold. One is to.
No, but now you have been directed to go before the appellate.
No, which was, if my lords were to kindly see my writ petition prayers, just one at page 36, man. That only addresses, in my respectful submission, possibly prayers 1 and 2. Page 36 of the writ appeal. Those are my writ petition prayers. 1 and 2 may be addressed by the learned single judge's order, but 1 and 2, my lords, I would respectfully submit, are predicated on 3, because 3 is my application for exemption from the application of the act itself. Now, it's essentially putting the cart before the horse, my lords, because without my application for exemption having been considered, they have passed an order. So therefore, my lords, if and the learned single judge's order does not address prayer number 3.
This cannot be decided by the appellate authority.
That can't be decided, my lord, because the under section 17(2)(a), it's only the Central Provident Fund Commissioner who has authority to consider my application. That's annexures C and C1. That is still kept pending for 4 years. Now, if my exemption is given, then the question of any attachment or any order would not arise. Retrospectively can be given, my lords. Section 17(2)(a) says the Central Provident Fund Commissioner, if requested so by the employer and subject to conditions so and so, whether prospectively or retrospectively may, if he is satisfied, exempt from the application of the act. So therefore, our request is for exemption of the application of the act, because the employees, they were covered. It's a mistake we made. We have several units. This unit somehow missed the bus. We did not seek exemption because they were already covered under another LIC scheme. So therefore, in fact, along with all the signatures of our employees also, we filed an application way back in 2020, albeit after the notice was issued. That's when it came to our notice.
Correct. Now, exemption is if you have an independent scheme or a trust.
Correct, Malas. And we have, which is what we have submitted, Malas.
You have a trust.
We have an independent scheme under the LIC, and all the employees, in fact, they themselves have signed saying that we are better off under that scheme than under the EPF scheme. So therefore, if that application, it may be rejected tomorrow, in which case I'll have to work out my remedies. But without that application having been considered, an order is passed and a subsequent attachment order is, that is my only urgency. Since I had the benefit of an interim order, if they proceed with the attachment, I understand it's only 7 days, I have to be fair, but till the next.
So now what is your main relief now in the appeal? You are seeking for revival of the writ proceedings?
No, Malas, to set aside, yes, Malas, possibly, and possibly send it back to the single judge to consider if a direction is given, even in the writ appeal, to consider the applications at annexure C and C1, and in the meantime, keep annexures A and B in abeyance. That also should resolve my grievance.
But you should have pressed for it earlier.
The learned single
C and
judge's order.
C1, no, C and C1.
Correct, Manoj. I'm not sure what transpired before the learned single judge, Manoj, but it appears as if possibly that, I'm not sure whether it was submitted or not.
Since
Yes.
it was 17/12/2020.
Correct, Manoj.
And the orders at A and B are subsequent.
Correct, subsequent. That's right.
So you should have challenged.
No, that's what, Manoj. I'll just give the sequence. On 17/12/20, we filed the application for exemption. That is after we received the notice. Then on 28/10/21 and 5/12/21, the orders were passed. And in our replies, Manoj, to the notice, we said that our application for exemption is pending. And despite that, the order was passed and the attachment order was
So
issued.
now what is the interim relief you are seeking?
To stay annexure A and B, Manoj. I'm sorry, it's there, application there. It's annexure A and B, which we enjoyed during the pendency of the writ petition. The interim order was granted on 20th December 21.
Correct, but then in effect,
Yes.
you are also to now if that order is stayed.
Yes.
If that order of
At the same time, I understand what you like. There should be ought to be a direction to the respondents also to consider C and C1. All of it is predicated on C and C1. If C and C1 is accepted, then automatically A and B also will go. But if
No,
C and
correct, now is for the time being.
Yes.
Suppose we were to stay the order of the single judge.
Yes.
And leave it at that.
Yes, Manoj. Or rather stay A and B, which is what we had sought for in the
Correct, but then
petition.
otherwise you will have to go before the appellate authority.
Correct.
Yes,
Manoj.
you are saying.
I'll have to
that-
file an appeal. That's right. I'll have to file an appeal challenging A and A. In fact, A is the impugned order.
But correct, but then in effect, the only appropriate relief would be a revival of the proceedings
Correct,
before the single judge.
I agree.
Isn't it?
Absolutely.
So in that context, your interim relief now, what do you want the?
My only apprehension, Malad, I'm instructed to submit that the attachment order of 5th of December was stayed if it is now given effect to because it.
So the order of attachment has to be stayed.
Yes, at annexure B, page 49, Malad.
What is A?
A is the order. A is the order under section 7A. And pursuant to the order under section 7A, order of attachment.
Correct. So A, B.
Yes.
And the final order of the single judge be stayed.
Yes.
Then you make your appropriate mention.
Yes.
Because there's no point it being stuck here.
That's true. I agree.
Perpetuity.
I agree. And during the vacation bench, honestly, if it was a regular bench, it could have been sent back to the learned single judge. But I quite see what your lordship is saying. If a date is
So
given.
then otherwise you will have to file an appeal.
That's right.
And then it will go on.
Then it will go on separately. That's right. But my grievance insofar as non-consideration of my application to section 17(2)A remains unaddressed.
Correct.
That's my main grievance.
The senior counsel appearing for the petition appellants submits that the learned single judge by the impugned order has relegated the appellant to avail remedy of appeal of a statutory appeal. Pointed out that the prayers made in the writ petition no doubt have sought to challenge the order at annexure A and annexure B, which are amenable to statutory appeal. However, the relief at Roman 3 relating to issuance of a direction for consideration of applications of the petitioner dated 17/12/2020 made under section 17 within bracket 2 capital A of the Act is a matter that cannot be looked into by the appellate authority. further submitted that the question of orders at annexure A and B being passed would not have arisen if application for exemption under section 17 capital 2A was considered before passing of the impugned orders. Full stop. Accordingly, it is submitted that the appellate authority under the statute would not be in a position to consider relief sought for by the petitioner. Full stop. In light of such contentions raised and noticing that the representation at annexure C and C1 are dated 17/12/2020, much before passing of the orders at annexure A and B, the case is made out to consider the interim relief sought for. Accordingly, there would be an order of stay of annexure A and B. Full stop. A and B.
Yes, sir.
Full stop. Further, in light of the contention that pursuant to the order of the learned single judge, petitioner is now to be driven to statutory appeal, it is also appropriate to stay the order of the learned single judge as well, passed in WP number so and so. Issue notice. Needless to state, it would be appropriate to observe that it's for the respondents without prejudice to the present proceedings who may consider the request at Roman 3 as well. Central Government Standing Council to accept notice for respondent. Any council is there?
The same, we'll take out one Mr. Venkatraman appeared for respondents 1 and 2
Learned
for the learned
counsel
single.
so and so.
KS
Who appeared in the
Venkatraman.
writ proceedings is permitted to directed to accept notice for respondent 1 and 2.
Great.
List after vacation. Yes.
Please, your lordship.
the
My lords,
limitation-
this is,
correct, the
this is a
limit-
child custody
No,
matter.
correct. But what we are saying that the limitation period would extend till post vacation.
Alla,
The operative portion of the order.
what happened is in between they
week
have
after-
taken away the child.
No, correct, but
They
then.
have taken away the child. That's where we are aggrieved. Otherwise, I would not have moved this case at all. I know my limitations. What happened was the limitation period, my lords, whatever it is, my lords, now the date of order, the date of order is
No, but operative portion.
12/11/2024.
Correct, operative portion of the order.
Yes, my lords. It says, it
1
says
month, 1 week from date of.
appeal period. Now, my lords, we had that. We filed it before that appeal period ended. That's on 16th itself. We had filed the case here before your lordship
No,
on
correct,
16/12.
but the order comes into effect. The order comes into effect from 1 week from the expiry of the appeal period.
Please, my lords.
Now, in the interregnum, if there is something, then you will have to.
No,
that
they have
is-
taken away the child. They have snatched the child. That's where, my lords, I'm very much aggrieved because had that not been the position, they have also filed the execution petition. That's another anomaly. They have filed the execution petition. And when the execution petition was pending, my lord, the court has ordered issue of notice on us. And our first appearance is on 4/11. Before that, what they have done is, they came there, took away the child, and then went off. We lodged a police complaint also.
Correct, ma'am. Who has taken away the child?
Mother and father.
Parents, my lord. Parents. I am appearing for the respondent. My parents
Just-
have taken.
Just 1 minute. Now we'll have it on the reopening day. Meanwhile, question of any further execution proceedings contrary to time granted in the order would not arise. That we can observe.
And
But
in the
insofar as-
meanwhile, we wanted to see the child, my lords. That's all our request was. Because the,
Yes, now what objection you can have if they want to see the child?
We are not having any objection, my lord. The only problem they have been actually administering medicine to the child unnecessarily. My lord, you may please to
No,
see
no,
the
I
paragraph
don't want
one.
to, please don't get into the merits, madam. We have
Yes,
read
my
the
lord.
order. We have read the
Yes,
order
my lord.
word to word. It's a highly
Yes.
contentious matter, and we can't at this stage of the vacation proceedings enter into it. It's
Yes, my
highly
lord.
contested. Both of you have your case. The
Yes.
only thing is, we will post it on the earliest date available after vacation. They're saying
Yes, ma'am.
they want to visit the child. Let them
Yes, my
visit.
lord.
Let them visit the child.
They can visit the child. We will permit them to visit the child. No
Yes.
problem. Yes. Meanwhile, they should not create any problem while visiting the child.
Yes,
It will
yes.
be
Bangalore Mediation Center, they can visit the child, ma'am.
Visiting at which venue?
in our house, my lord, because the child need not be taken again to the courts because he's actually going through a lot because of all this problem.
No.
In
Otherwise,
our house, they can visit. They can visit the child in our house.
But correct, now, in light of the kind of allegations and cross allegation, let it be at a neutral place. Let it
Yes,
be
my
at the
lord.
mediation center.
Yes, with prior notice. Yes.
No, you will fix it now itself. Now we'll
Yes,
fix
my
it
lord.
now itself. Between
Yes.
now and the 6th,
Yes.
between now and the 6th, we will fix a time. Now,
Yes.
between now and the 6th, when do you want to visit?
Well, let the child be brought to the Bangalore Mediation Center tomorrow. Today also it's okay, Malars, between 2 and 5 today.
Let us see. Tomorrow.
To-
We'll fix it tomorrow.
My lord, the child and the parents are in Mumbai. Can it be between 6? The child is with the in the father's house in Mumbai.
Correct. So what we'll do, we'll pass over. You find out between now
Yes, my
and the
lord.
6th. Between
Yes, my
now and
lord.
the 6th, you give a date.
Yes, my
Preferably tomorrow, day after tomorrow, you give a date. We'll fix it.
Yes, ma'am.
Pass,
Yes,
pass,
ma'am.
pass.
Yes.
Grateful, Malars. My colleagues will be here.
Yes. Pass.
Serial number 16 and 17 are connected.
Yes.
The petitioner would be relieved from the contract appointment.
31/1/2023 is the order you're challenging.
My lord, the impugned order, now the urgency is, my lord, your lordship may kindly see annexure M, my lord.
No.
My lord, the reason is, my lord, that he'll be relieved from the contract.
Order of KAT.
Yes, my lord, I agree, my lord.
Why you didn't challenge them?
My lord, I had filed it on 10/12/24 itself, my lord, the matter was not listed.
No.
Now the urgency is, your lordship may kindly see annexure M, my lord.
Just one. Order of the KAT is dated
Yes,
31st, 20.
Yes, ma'am. Yes,
Why
ma'am.
you didn't challenge?
My lord, I had made representation to the authorities, my lord. Your lordship may kindly see the reason for approaching the vacation bench, my lord. Annexure M for a moment, my lord. For a moment, annexure M, my lord.
So before that, what is the effect of the order of the KAT?
Lord, effect of the order, the endorsement issued by the government, my lord, stating that I have my resignation under 252B cannot be considered is the one which has been rejected by the tribunal. Now, my lord, I am being relieved from my office, my lord, on the temporary basis by virtue of which, my lord, I had reported on 1/1/2025. Lord, tomorrow I will be relieved. I'll have to go and report before the first respondent. Let the reporting be subject to pending writ petition, my lord.
The reporting?
Reporting before the first respondent on relieving from the contract terms, my lord, be subject to pending writ petition, my lord. Your lordship may kindly see annexure M for a moment, my lord. I am being relieved. Page 280, my lord.
Page?
280, my lord.
Just read.
This contract period is only till 1/1/2025. I'll have to go and report before the first respondent. Let the reporting be.
Read annexure M.
Yes, ma'am. With reference to your appointment letter dated 2/7/2018 and other letters dated 15/3/19, 19/6/21, 17/6/22, 17/11/22, and 28/3/23, the management of GMRC Limited has decided to renew your contract for a further period of 1 year with effect from 2/1/24 to 1/1/25. All other terms and conditions mentioned in the appointment letter dated so and so remains unchanged. Also, if your performance is not found satisfactory, the management has the right to discontinue your services in terms of clause 10 of your appointment letter dated 2/7/2018.
Now, just 1 minute to understand. Now, once you are relieved
Yes, ma'am.
from GMRC,
Yes, ma'am.
what happens?
I have to go and report before the parent department because I was on deputation.
Parent department is,
The first respondent, water resource department,
so you're saying in the event you are
relieved. I'll have to report before the parent department.
So what is the?
I may be permitted to report before the parent department by virtue of relieving from the temporary contract period.
But then you have resigned there.
No, that is 252B. It is with an intention to take appointment that lien will continue in the parent department.
That without hearing the other side. How?
Lien, rule, your lordship may kindly see the rule itself.
No, but why you didn't challenge the order of the KAT?
I had made representation stating that the endorsement could not have been issued. Even after the order of the tribunal, my lord, I had several representation. I was assured that I'll be permitted to report back to duty.
Order is passed in 23.
Yes, my lord. He had made representations seeking indulgence of the government, my lord, and the BMRCL to, my lord, recommend for my continuation. But that was not considered. But my only submission is I may be permitted to report before the first respondent, making it subject to pending writ petition.
That how we can do it contrary to the order of the KAT, which remains unchallenged.
Order of KAT is only insofar as rejecting my endorsement is concerned. It doesn't say anything about reporting back. That endorsement was challenged on the ground that my lien itself would not exist on the ground that Rule 252B is not attracted. But that is not the reason. But the tribunal proceeds on the footing that I was appointed by a company.
But you should have challenged the order of the KAT here.
For that reason, my lord, I cannot be, my lord, permitted not to report before the first respondent, that too subject to pending writ petition, my lord.
No, that how can we grant such an order?
Without that, my lord, the very writ petition would become infructuous.
So I'll keep it open.
The writ petition itself becomes infructuous by virtue of not reporting to the duty, my lord, and there will be no continuity of service.
How can we direct that unless the validity of the order of the KAT is?
The validity of order KAT is only insofar as endorsement is concerned. Kindly see the impugned endorsement. What is the endorsement that is issued?
Page?
That is at page 88, my lord.
Now, who is the parent department?
Water resource department.
Government.
Yes.
My lord, if I may submit, my lord.
You appear for?
My lord, I appear for the government.
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 Just one, I'll come to you. Page 80?
Page 88, my lord.
So what is the effect of the endorsement?
This endorsement, your last paragraph, ಮೇಲೆ ವ್ಯವಸ್ಥೆ ಎಲ್ಲಾ ಕಾರಣಗಳಿಂದಾಗಿ ಜಲಸಂಪನ್ಮೂಲ ಇಲಾಖೆ ಸೇವೆಗೆ ಪುನಃ ಹಾಜರಾಗುವ ಮತ್ತು ಮಾತೃ ಇಲಾಖೆಯಲ್ಲಿನ ಹುದ್ದೆಯಲ್ಲಿನ ಹಕ್ಕನ್ನು ಲೀನ್ ಮುಂದುವರಿಸುವಂತೆ ಕೋರಿ ಸಲ್ಲಿಸಿರುವ ನಿಮ್ಮ ದಿನಾಂಕ 8/3/18, 12/10/17 ಹಾಗೂ 30/8/19 ಮನವಿಗಳನ್ನು ಪುರಸ್ಕರಿಸಲು ನಿಯಮಗಳಲ್ಲಿ ಅವಕಾಶವಿಲ್ಲವೆಂದು ತಮಗೆ ತಿಳಿಸಲಾಗಿದೆ.
Correct. Now the effect of that endorsement is that your request to report to the water resource department was rejected.
Yes.
Isn't it?
Yes.
That you challenged before the KAT.
Yes.
Now KAT has rejected it.
Yes.
Then you should have challenged it.
Yes, my lord, but in view of the representations made by him, my lord, seeking indulgence of the deputed corporation as well as the government, my lord, he could not approach the tribunal, my lord.
Yes, what do you say?
My lord, it is an admitted fact that he has not at all been issued an appointment letter. It is found in the list of dates. My lord, what the petitioner essentially did was he tried to travel in two boats at the same time, my lord. He was initially appointed on contract basis in the government department, WRD, and he voluntarily sought appointment on contract basis in BMRCL later on. Now, there is no appointment because seeing that he was already appointed in BMRCL on contract basis, he was not given appointment letters along with others who were on contract basis in the WRD department. There is no, it is an admitted fact that he has not at all, to have lien in the parent department, he should have been appointed in the parent department. It is an admitted fact that he has not been appointed. And KCSR, to be applicable, he should have been a regular employee. He was not, when 252B was, relieving letter was issued, he was not in government service at all. KCSR was not applicable at all because he was not on permanent appointment.
Irrespective of that, you are saying there was no formal letter of appointment.
No,
it
is an admitted fact.
That is an issue. That is disputed by you.
No, my lord, he has not been. It's not even disputed. It's an admitted fact that he has not been issued appointment letter.
Is there any letter?
Your lordship may kindly see page 234, my lord. This is the order of appointment issued to all the persons whose names appeared in the select list of KPSC. Page 234. Lord, my name is at page 238. Serial number 41.
No, this is the selection.
No, this is the appointment order pursuant to select list of KPSC. My name was there in the select list. Lord, pursuant to the final select list issued by the KPSC, my lord, the appointment order has been issued on 2010-2015. As on that date, my lord, I was on deputation.
My
Now
lord,
kindly see what is the observation made at page 238. Serial number 41. Lord, ಸರ್ಕಾರದ ಅಧಿಸೂಚನೆ ದಿನಾಂಕ 15/11/14 ಅನ್ವಯ ಸದರಿ ಅವರ ಸರ್ಕಾರದ ಸೇವೆಯಿಂದ ಸ್ವಯಂ ಆಗಿ ಸಹಾಯಕ ಇಂಜಿನಿಯರ್ ಹುದ್ದೆಗೆ ರಾಜೀನಾಮೆ ನೀಡಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಇವರ ನೇಮಕಾತಿಯನ್ನು ಕೈಬಿಡಲಾಗಿದೆ. Lord, ಸ್ವಯಂ ಆಗಿ ರಾಜೀನಾಮೆ ಅಂಡರ್ ರೂಲ್ 252B. That is my lord with
252B. KCS.
Resignation of an appointment to take up with proper permission another appointment, whether permanent or temporary service, in which counts in full or in part, is not a resignation of public service.
Correct, but the context in which 252B is that in order to consider continuity in service, your first place of posting,
Yes,
that would be counted. So your technical resignation under the first employer cannot be discounted, isn't it? That
Yes.
is the object.
Yes.
So now let's assume you are relieved from that GMRCS.
Yes.
Then whether your resignation now
It
is
cannot be termed as a resignation. It's your lordship may kindly resignation of your lordship may kindly see resignation of an appointment to take up with proper permission another appointment, whether permanent or temporary service, in which counts in full or in part, is not a resignation of public service.
only for the
Purpose of taking up the job, and I can continue because of the lien. Your lordship may kindly see note 4 of the rule 20, my lord. Rule 20 of the same. Note 4, my lord.
Rule 20.
Yes, ma'am. Under Rule 20, Note 4, my lord. Rule 20 relates to, my lord, the lien, continuation of lien. Now, Lakshmi, kindly come to Rule 4, Note 4.
Read.
My lord, when a government servant who has secured employment in one department of the government under the rules of recruitment seeks employment on his own accord in another unit or department or in another cadre or grade in the same department, his lien on the original appointment shall be continued to be maintained provided he has already been confirmed in the post till he is permanently absorbed in the department or a cadre which he is newly appointed, and he has been given the benefit of the past service for the purpose of leave and pension. If, however, he is temporary in the first appointment, he will cease to have any connection with the old appointment, but he shall be given only the benefit of the past service of leave and pension.
Now, what is your status in the original employment?
Original employment, what has happened is, my lord, by virtue of the absorption rules that were challenged before the dishonorable court, my lord, 2002 rules, by virtue of which the petitioner was absorbed, that rules were quashed. The High Court directed the KPSC to redo the entire list. In the meantime, when the process of redoing in the list was there, he was on deputation, my lord. As on the date when he was deputed, he was a government servant under the 2002 absorption rules, which was set aside in 2012.
If the absorption rules are set
aside, direction was given to redo the entire selection.
What happened to that?
That reselect list was issued, my lord, in 2015. My name appears in the final select list. Your lordship may kindly see at page number 179, my lord. This is the final select list issued by KPSC at page 172. It starts at 172. Blood. This is the final select list that was issued pursuant to the direction issued by the Honorable High Court as well as Apex Court, my lord. Lord, my name appears at serial number 58, page 179.
This is the provisional select list.
No, it is a final select list. But pursuant to which, my lord, the appointment orders were issued. In this list, my lord, my name is at serial number 58.
Serial number
58. Now, my lord, pursuant to this final select list, my lord, the appointment order is issued, which I have produced, my lord, at page 280, my lord. 238, my lord. 234 is the appointment order. Now, in my case, my lord, they say that because I have submitted my resignation, Swayam Nivritti application, appointment order is not issued. But by virtue of this, my lord, my appointment would not wipe out. My name is there in the select list.
Yes.
Lord, for 252 to be applicable, my lord, he should be in permanent appointment. Can I
Correct.
just take your lordships to the
Correct.
finding of the tribunal?
No, correct.
Please.
Now, he is contending that after the rules were set aside, there was a direction to redo the rules.
Please,
In terms of that direction, Annexure K was passed.
please.
Annexure K is the final select list.
Yes.
So that would date back in effect to the position
In
of,
2002.
as on the date of his
Rules.
resignation.
Please. If he had been issued an appointment, but to say that he has a lien, my lord,
Annexure K,
please,
Annexure K is pursuant to some judicial orders
please.
of redoing that list.
Yes.
Now, if the list is redone, then his original absorption or appointment, whatever was done, that would now become a full.
Relate back to the date on which he was appointed on contract basis. My lord, that may be true, my lord, but my first submission is this, my lord. He has not been appointed. To say that he has a lien. The
Let us
second
see.
thing, my lord, 252 is for taking up new appointment. It is not deputation.
No, correct.
It is not deputation.
But that has been accepted by
20 note 4
Please.
says that his lien on the original post continues unless he is temporary.
Temp.
Now, whether he was temporary, contractual, which you are contending, is a matter to be decided.
Please.
If you were to eventually succeed in your contention, then he will go. That we can make it clear. But because of K, he needs some protection, the continuance of which in the Water Resource Department would be subject to orders to be passed. Let the court consider.
My lord, matter may be called after vacation, my lord, because of the
Correct.
having
Now,
regard to the
first, now New Year is the D-Day for him. He
there was
goes
no
out of-
interim order here. He did not seek any interim order before the tribunal.
No,
At that time, that was not
just-
necessary.
That question never arose because he was in GMRCL.
Yes.
Now GMRCL is terminating.
And he was aware that it was going to come to an end on
Correct. So now the
1st of January.
technically now is the cause of action for him.
My lord, to send him back, there must be an appointment. So to send him back, there is no appointment letter. He has no
Annexure K.
lien to any of the posts.
Annexure K.
My lord, it's not an appointment order. Your lordships may kindly see the finding of the tribunal at page 39, my lord.
Page
39, my lord.
Yes.
My lord, the fourth line from the top, my lord, towards on the right hand side, in this regard.
Yes.
My lord, may I read from the second line itself? It is the contention of the learned counsel for the applicant that the applicant was appointed to government service on the basis of this selection by KPSC. In this regard, the learned counsel places reliance on A13 and A3, both dated 10/2/2015. We have perused the said annexure A3 and A13. A3 is a communication by KPSC to the applicant regarding his selection to the post of assistant engineer on the basis of special recruitment made under the special rules of 2013. Annexure A13 is the communication of KPSC to the appointing authority forwarding the select list for necessary action at their end. There is no order of appointment that has been issued by the appointing authority that has been pleaded in the application for the contention that the applicant has been appointed to government service on the basis of the select list of KPSC dated 3/2/2015. Thereafter, my lord, your lordships may turn to page 43.
Yes.
Page 43, my lord. My lord, middle of the page, my lord, the applicant has terminated. The applicant has terminated his association with the company. The applicant has terminated his association with the company on his own accord, and he never held any permanent post in the company or the government, since at the relevant time when he resigned from the service of the company, the absorption in the service of the company by order dated 25/2/2002 had been finally set aside by the Honorable Supreme Court. The applicant was not a government servant at all at the relevant time when he resigned from the service of the company and held no lien either in the post in the company or nor in the government.
Correct.
Therefore,
No, just one. Now that 25/2/2002 order of the Supreme Court is the order perhaps which said you redo it, isn't it?
Yes. No.
that was the initial absorption order, which was successfully challenged before the High Court and confirmed by the Supreme Court.
Correct. After which they made some rules.
Yes.
In 2015, by giving, instead of absorption, weightage was given to the service rendered on contract basis. And the petitioner tried to secure appointment in BMRCL. He did not tried to continue in the same department, WRD. Now he has to suffer the consequences of his own choices. What he wants is to come back to the parent department when there is no parent department. He has not been given any appointment order at all. Apart from this, my lord, in fact, the date of appointment in 2015, when they were appointed based on service weightage, relating back to the date of their initial appointment, that is under challenge in another petition, my lord. This matter can be clubbed with that and can be heard together, my lord. In fact, at this stage, if interim order is granted, there is no basis at all because there is no appointment order at all. For him to be even given a posting in the WR, there is no appointment order.
It requires some consideration.
Lord, my only submission is this, Lord. The observation made in the appointment order while rejecting his appointment order, Lord, they specifically say that I have resigned on under Rule 252B. By virtue of resignation, my Lord, they did not issue me an appointment order. Lord, having completed the contract period, my Lord, when I am reporting back, they should issue an appointment order. That was the contention raised before the trial.
So for which by interim order we can't.
No, I am not seeking an interim order to directly, my Lord, permit me to appoint me, my Lord. I am only seeking to report because so that otherwise, my Lord, I will lose my continuity of service, my Lord. Let it be subject to pending writ petition. I have no objection for that.
No. Now, what is the relief, interim relief you are seeking now?
No, permit me to report before the first respondent till the finalization of this writ petition. If I succeed, my Lord, I will be continued in service.
We can observe that otherwise the other way of looking at it,
please,
is that we could observe that your contention that pursuant to annexure K, you are entitled for an appointment order, which is a consequential order, which was not hitherto pressed because you were working at GMRCL.
Yes,
is kept open. Is kept open and would be subject to orders to be passed in the proceedings.
Till such time, I will be permitted to report.
But if you were to report, then they have to treat you as an employee, pay you, you'll have to work.
That automatically I am entitled to, my Lord, by virtue of the appointment order that is issued to me.
Question has to be decided.
Lord, that issue, my Lord, has already been decided insofar as appointment on permanent basis is concerned.
My Lord, there is a matter pending, my Lord, insofar as
No, but these findings you should have challenged. Look at the, just one minute.
I agree, my Lord. I have come within the time prescribed, my Lord. Within the time prescribed, I have approached this honorable court. But by virtue of the interim order, what I am seeking is may not be the stay of the order of the tribunal. I am only seeking protection, my Lord, till the finalization of this writ petition.
The observation at paragraph 14 has been in force for 2 years. Look at the observation at, just read paragraph 14, page 45. Just read it.
The petitioner for the submission that while he was working on contract.
Page 45, paragraph 14 of the order of the tribunal. In
In
view
view
of
of the facts and circumstances explained above, the applicant is not entitled to a prior shot in the application since he was not a government servant. Now, my lord,
finish it, I think.
at all, in the time he was in service in BMRCL for in the first instance in 2007, he was at best a temporary employee in the company, KBJNL, and held no lien either in service of the company or the government, since the temporary employee has no lien to a post in the company or the government. Although he was deputed to BMRCL in 2007 for a period of 3 years only, his continuation of BMRCL first contract expired in 3 years. He is without any concurrence of any authority of the company and or the government. His appointment in BMRCL Deputy Chief Engineer is also without the approval of the authority of the company government. All these documents are placed before the tribunal, my lord, and I have been continued on deputation with the approval of the first respondent. And secondly, my lord, the tribunal's observation is that I am an employee of a company, that is KBJNL. I was never a employee of the company. Your lordship may kindly see the impugned orders, my lord. The order which I have produced categorically shows that, my lord, I was appointed by the first respondent.
Correct, but you are not diligent. You should have challenged the.
Lord, my only submission is, my lord, I had approached the authorities, my lord, to my lord, ensure that they consider my representation, my lord. That having not been done, my lord, I am before this honorable court, my lord, merely because there's a delay, my lord, but that delay would not take away my right, my lord. By virtue of the impugned order, my lord, which is now being coming in my this one, my lord, your lordship may kindly say I am likely to be relieved on 1/1/2025.
Let us see, I'll keep it open. I'll make it clear. The petitioner has challenged the order of the tribunal dated 31/1/2023, whereby the endorsement issued to the petitioner at annexure M, at annexure, endorsement at annexure.
No, that is at annexure page 88. Annexure A11, page 88.
Whereby the endorsement issued to the petitioner dated 19/12/2019, declining to permit the petitioner to continue in the parent department. Full stop. It is the case of the petitioner that in terms of annexation. Now, otherwise I'll not pass any observation. I'll keep it open. Let us. Any observation that I make.
That is the case, my lord. Let there be some sort of a protection, my lord. That is what I am only making a request, my lord. Otherwise, he will have to report before he will. Lord, he will lose the continuity of service, my lord.
The petitioner, no, that I'll keep it open. That I'll make an observation.
Please.
That effect. The petitioner has challenged the order of the KAT passed in application 95/2020, whereby the petitioner's request to construe him to be an employee of the Water Resource Department and to enable him to report came to be rejected. The tribunal, as per its order dated 31st January 2023, has dismissed the application, refusing to set aside the endorsement. Full stop. Petitioner submits that in the meanwhile, he was working with GMRCL, and consequent to the completion of tenure at GMRCL, he may be permitted to report back to the parent department by taking note of note number 4 to Rule 20 of the KCSR, read with the Rule 252B. And government advocate submits that he requires some time to take a detailed stand, and further would submit that for the purpose of construing the petitioner to have a lien, it is necessary that the petitioner's appointment be demonstrated. Matter requires consideration, including the request as regards the interim prayer. Full stop. List the matter on the reopening day before the roster bench. Full stop. It's made clear that if the petitioners relieving from GMRCL as per in terms of annexure M is a matter to be taken note of appropriately, and if the petitioner were to succeed in obtaining an interim order upon hearing or obtains a favorable order from the bench eventually, the time between time between 1/1/2025 onwards is a matter to be taken note of by the court eventually, so as to ensure that no prejudice to continuity in service is caused if the entitlement of the petition is established. Relist the matter on. What is your grievance now?
Grievance is what happened was the petitioners are all the local residents of Ward number
So if
140.
they're doing white topping, it's beneficial for you. How are you agreeing?
No, it is both. It is not only the question of inconvenience to us, which we had undergone otherwise, and it is the loss of to the exchequer for which we are paying tax.
No, that
Well,
makes it- that is an issue that's not free from doubt. That is a matter that requires hearing regarding loss of exchequer. Now, if they want to remove the
No, your lordship may
bitumen
kindly-
road, if they whatever bitumen road has been done, they will relay it with the topping. That's a policy decision of the government. How are you agreeing?
Correct. If the policy decision were to come, subsequently it is one thing. Your lordship may kindly see the dates. What they do is 8/2/1924, they issue work order 2 months before they call for the tender. On that very day itself, 8/2/24, white topping tender is called for. Both are on the same day. Please see.
No, now has it been asphalted?
Yes.
When?
Within 270 days, as per the work order, 2 months back, asphalting is complete.
Correct. Now the
road is fantastic.
Correct. No, that's according to you, it's fantastic. They want to do it for
No.
30 years. They want to
And
do white
now
topping.
now what they say is, it requires white topping.
That's their decision, not our decision.
No, it is their decision. Correct. Now, whether that decision of white topping, is it policy decision can be questioned, my lord, if it is arbitrary and not bona fide.
What is arbitrary and white topping?
Arbitrariness is this. The arbitrariness is this, that on the date on which 8/2/2024, when they decided to lay the tar road itself, it was open for them to lay, my lord, the white topping. Nobody would have come in the way. Now they do it, they draw about 29 crores for laying the road. On that very day itself, now they come out with 93 crore project.
White topping.
White topping.
Correct.
Now they have to.
White topping is done on what? On the same asphalt.
No. Asphalting will be removed. Asphalting is being removed. Roads are being dug. Now the question is.
Just one part is there's a loss for exchequer. No, there'll be an inquiry of who's responsible for floating the first tender. That doesn't mean you must not do white topping.
No, I'm not saying that they cannot do white topping.
So this will let there be an inquiry how they took the decision to re-asphalt the road when they were doing white topping. Let there be an inquiry. But why are you protesting against the new tender?
Till such time, my lord, if they go ahead with in the inquiry, if it reveals.
No.
In the inquiry, it reveals that it was not necessary at all.
No, that is a decision that you can't enter.
No,
How-
I'm not.
How are you saying it's not necessary?
My lord,
How are you saying it's not necessary?
how I'm saying that
No,
it is
that's
not
technical.
necessary.
Neither the court nor you are competent. to
No,
talk
I'm not competent.
Ah.
I'm not
We are
saying
also
that.
not competent. That's a matter.
No,
within
I'm
their
only
discretion.
bringing to your lordships. I'm not, my lord, bringing to your lordships about the necessity or otherwise. No, I'm only bringing to your lordships about the arbitrariness of the
That will
policy.
keep it open. Accountability will be fixed.
My lord, your lordships have time and again held.
No, we'll keep,
The
accountability
policy
will be
decision-
fixed.
No, by virtue of this, ultimately, if your lordship comes to the decision that the policy decision is totally arbitrary, then what happens? Then what? The resultant effect is this cannot be redone. The policy, my lord, as such.
I don't know. We can't.
Well,
have-
so apex
you
court, my
can't
lord, has
take a-
time and
No,
again.
no, you can't take such a narrow view on policy decisions of the government. If there's any loss, accountability will be fixed. That will make an observation. You can't stall the white topping. How can you stall the white topping? How can you stall the white topping?
Yes, my lord.
No, no.
White
You can't.
topping is as such.
Yes,
The
but
asphalted road, according to their policy, where is that policy?
yes, BBMP, what do you say?
Please, your lordships, I appear for the BBMP. Your lordships, the matter may be taken up soon after vacations. I'm yet to seek instructions in this matter, your lordships.
What is the present status of the work? What is the present status?
We have produced the photographs.
What is the status?
They have brought the JCBs and they brought the material to take out the entire this thing.
It has not been taken out.
Not been. I'm only
The
concerned about ward number 140.
No, that's okay.
That's it. That's it.
No, no, that we'll see. We can't take a packaged view of this. If it's throughout this, throughout the city, which other examples, we have to examine it together.
Correct.
But we can't stall these projects with that.
But
Accountability
what
has to be
happens is
fixed.
that supposing at the
Accountability will be fixed. We will make an observation. Let there be an inquiry. How they did this double project. We'll keep it open for consideration. Let accountability be fixed.
what is happening, my lord, in
But you can't stall
in
it.
Bangalore? No. Apart from this, every decision, my lord, in relation to laying up the road and the white topping, this very process is being followed. The reason is very obvious.
No, that we'll see. That's
The reason is very obvious.
that we may be with you, but we cannot.
I
record
cannot
a
pitch it
finding.
beyond that.
No, correct.
I
We
cannot
agree.
pitch it beyond that.
No, we agree with you that we cannot, there may not be material to record a affirmative finding on what you feel may be a suspicion, which may be a practice. We don't disagree with you, but that requires some material to record a positive finding of whether there is any ulterior motive.
Correct.
We are with you on that, but what we are only saying that if now they're going to do white topping, we can't stall it. But if it is your contention that while re-asphalting the road at an earlier point of time, they were aware of this white topping and this could have been avoided, that's a matter that has to be put to them. They have to take their response. We will see. But to stall the white topping may not be proper at this point. Though your point is well taken and that's an aspect that is kept open. We'll keep it open. Let the court call upon them to defend the decision and see what is to be done.
That very what your lordships are proposing to do. My lord, that's the best that can be, my lord, done. My only humble submission is that this thing has been done about 2 months back, they completed. Now again, the whole thing in 1 month, waiting for 1 month, your lordship may kindly direct to have some kind of an inquiry, what they want to have.
That cannot
Till
be.
such time, my lord, your lordship may kindly see the last order, my lord.
Yes, what are the instructions now?
Your
Their
lordships,
only contention is that you decided to re-asphalt the road at a particular point of time and you have invested some money. Money has been spent.
please, your lordships,
Meanwhile, you want to do white topping.
please.
And you are aware that white topping would be done. If it was to be so, why did you spend money on re-asphalting the road? Is there only assertion? So how are you going to defend it if white topping was going to be done and you are going to remove what has been re-asphalted? It's a waste of public money is what they're saying. What do you say?
please, your lordships, on such things, I'll seek instructions, your lordships. It might be taken up on the day of reopening. I'll make my submissions on that, your lordships. And thereafter, if required, an inquiry can also be ordered for.
Annexure C,
Page number, my lord.
page 27, that work order,
Yes.
you just look at the subject.
Correct.
It says road drains.
Roads, comma, drains.
No, road drains. It's
No,
comma.
that is comma should have been there. It is left. There is no dispute about that.
No, that we don't.
This work,
Correct. That requires we'll make an observation. Let them clarify.
road, drains, footpath in ward number 137, 138 and 140. Entire work, my lord, was complete about 2 months back. My lord, it is for my benefit. My lord, I am. Page number. Lord, we are the residents.
No, that's
if it is for benefit, our own benefit,
correct.
if we have to, my lord, if I wouldn't have come before your lordship.
No, white top, correct. White topping, why are you protesting? There's no grievance. Your grievance is only on the amount of loss.
The entire thing, and also, my lord, this kind of every now and then redoing the thing.
That's a larger issue.
What happens, my lord?
That we'll see at a later point.
My lord, some interim protection.
No, we'll make them accountable. Let us see. Yeah, their risk if they're going to do, let them answer. The Peru's learned senior counsel appearing for the petitioners submits that the work order for white topping was issued on 20th of June 2024.
Yes.
And for the very same road,
8/2/2024.
the work order
White topping
for development of road, drains and footpath was issued on 8/2/2024. Full stop. It is submitted that pursuant to the work order of 8/2/2024, road has been asphalted.
Yes.
And public money spent. And if the authorities were aware of their future work of white topping as on issuance of work order at Annexure C, there would be a loss to the public exchequer as the re-asphalted roads would again be subjected to white topping by removing the asphalt.
Asphalt.
Full stop. The respondent BBMP to take their stand in light of such contention
whether
raised
payment is to be made.
by the next date.
I may be permitted
My
to
lord,
file my
may-
wakalat, your lordships. I may be permitted to file my wakalat. for you.
So and so is permitted to file wakalat for the respondent. List the matter on sixth.
My lord, one more, this thing, on 8/2/2024, your lordships observed that the work order was issued for, my lord, asphalting, road and drain. On that very day, tender was issued for that is on 8/2/24 only. Work order comes to be issued 3 months later. Within the entire thing, the asphalting is going on. It's very obvious.
Let us relist the matter on sixth.
Oblige me.
My lord, in this case, I have challenged annexed J, my lord.
Just one
the
minute.
order.
Just 1 minute. Our whispers are being recorded. That's a little troublesome. Where is the copy of petition in WP 31137 page? Copy of the petition we want to have a look at. Your prayer before the single judge.
Prayer, my lord, I have seek only extension of that order, my lord, annexed J.
No. Please take us to your writ petition before the learned single judge.
Yes, my lord.
Where is the petition copy?
I didn't file the petition.
How did you go before the single judge?
My lord.
Now the DRAT
Yes, my lord.
order is at annexure J.
Yes, my lord.
It gave you 2 weeks time from 22/11/24.
From 8/11 to
Ah.
till 22/11,
11
they have
to-
granted me time.
Ah. Now, what was pending before the single judge?
There I am not pending, my lord. The order is passed.
3
314-194.
31137 was filed in which, regarding which order?
Same order, my lord. I have not challenged that order.
No, you are not challenging. We want to know.
Ah.
WP 31137 was filed against which order? 31137. Go to page 75.
Yes, my lord. In that one, my lord, I have sought only for direction and extension of the order passed by the DRAT.
How can you ask before the single judge? How could you have got an order by misleading the court?
No, my lord.
How does the single judge have jurisdiction against order of DRAT?
Yes.
How does the single judge have jurisdiction?
Even I have asked question before the
No, not
scrutinized, my lord.
No.
They said
We
if you
smell
are,
something fishy.
no, my lord, if you are challenging the order, then it will come before the division bench. Only seeking extension of the order means it will come before the
Wrong.
single judge.
It's that order at annexure K is wrong. You cannot have the benefit of that order. How can you go before the single judge against an order of DRAT and get an extension? That extension can be done only by a division bench.
Division bench. I have raised the same, my lord. That is the reason I have
You are
kept
the
it two
beneficiary
sets.
of.
2 sets at the filing counter only. I have kept 2 sets.
No, that is up to you. We don't want to say anything more, but definitely it doesn't inspire confidence.
I'll file memo for withdrawal. I already
No, no,
filed, my lord. If
We can.
I'll
Now we'll only have it after. Now, what is your plea? You want extension of time?
Yes, my lord. And because, my lord, in this case, the bank has taken possession and has sold the
Maybe.
property
How
to
did you
the.
file? How did you file 31137 and get an order for extension of time? Even that time is finished.
Yes, my lord.
You could have gone there only. It's impermissible.
It's
You are having 2 litigations as of now, one before the single judge and one here.
kindly have it on reopened, my lord. I'll clarify and I'll come before the.
The petitioner has challenged the order of DRAT at annexure J. Whereby DRAT has granted time for deposit of 50% within 2 weeks from 22/11/2024, failing which appeal would stand rejected. The petitioner in the relief in the petitioner has sought for relief of direction to the effect that pre-deposit amount is to be waived off. It is noticed that in terms of the interim order, interim direction at annexure K, dated 22/11/2024 in WP 31137 of 2024. Time was extended for a period of 4 weeks from 22/11/2024 for the pre-deposit. Admittedly, till date, pre-deposit amount has not been made good. Full stop. Taking note that petitioner had sought for relief in WP 31137 of 2024, which same relief is sought for in the present proceedings. That aspect requires explanation from the petitioner. Full stop. Relist the matter in the week commencing from. Yes.
Petition.
Let it come up on the reopening day. We'll see.
That's the only difficulty is the endorsement issued, my lords. The tribunal, my lords, acknowledges the urgency and the gravity of the situation, my lords, that promotions will be operated shortly. Despite that, my lords, an interim order protection is not granted.
No, correct. The next date they've said without fail. Look at what the
My lords, then, my
KT,
lords,
look at what the KT has observed. Isn't it?
page 30.
So it says our respondent 1 to 4 to file reply statement without fail. So court is acutely conscious of your urgency.
My lords,
They
for
may decide.
some reason, if the matter is still not taken up, my lords,
Let us see.
and the promotions are operated, my application becomes infructuous.
That we'll see. Always promotions we can't stay.
My
Our
lords,
promotion stayed. No.
it's not for staying the promotions, my lords. It's a statewide cadre list, my lords,
Let us
seniority
see.
list that is operated.
So let the regular.
Interpreting a government order, my lords, now they want to operate divisional
Let us see.
seniority.
We'll have it
lists.
after the next date of the KAT.
9/1/25.
Let us see. Let it be after that. Immediately after that, we'll see what happens
Please.
before the KAT. If you don't take, then you are at
Please, my lord, and this is a policy matter.
that will
Which
see.
is-
I'm not entering
yes.
into the merits.
Yes, yes, yes.
It is noticed that the petitioner has challenged the order of issuance of notice by the tribunal. Full stop. Though various contentions have been raised, having the order of 19/12/2024 is perused, and the tribunal has been acutely conscious of the urgency, as noted in its order. Full stop. Further, tribunal has also observed that the respondent state to file their statement without fail by the next date. You will be able to file.
Yes, my lord.
The
Please. Will be-
respondent state submits that they would comply with such direction and take their stand. Full stop. Noticing that the date is fixed before the KT is 9/1/2025. This is the matter thereafter. 9th ಆದ್ಮೇಲೆ ಒಂದು ಡೇಟ್ ಒಂದು 3-4 ದಿನ ಆದ್ಮೇಲೆ ಡೇಟ್.
I'll take notice for 1 to 4, my lord.
16. AG accepts notice for response 1 to 4.
My lords,
Yes.
your lordships kindly leave. My lords, the first office objection, my lords, pertains to court fee. There is only one petitioner.
Only
Only one petitioner has approached this honorable court, my lords. The first office objection.
or is it some multiplicity of reliefs or only one?
My lords, one relief which is arising out of the same application. The other respondents are my counterparts.
Office objection at seal number 1 is kept in abeyance for the present in light of petitioners, counsel for petitioner submitting that the petition is by only one petition.
Please, my lords.
Others you comply. Other office objections to be complied. Yes.
Great.
I appear for the petition.
KEA.
Yes, my lord.
Hmm.
Ramesh, name may be shown. My lord,
in this matter, my lord, as per my instruction, my lord, the admission order will be uploaded in the website within an half an hour. Order of admission. That is their prayer, my lord. It will become,
Petitioners.
yes, ma'am. If she petitioner by herself, if she goes over there, they will give the copy of admission order, my lord.
So we'll pass over.
Yes, my lord.
By 1:30, we'll take it up.
Yes, my lord.
If there ends your dispute.
Yes, ma'am.
Pass.
Much obliged.
Of this order, my lords, the create is under challenge. But what was
But it's
challenged?
listed, correct.
It's listed on sixth.
Sixth.
I understand, my lords.
Take
I-
care.
But
Take
my, honestly, my lords, only apprehension is before the sixth, if somebody is posted in my place, that's all. Otherwise, I'll argue it on sixth. The suspension order is, I would submit, my lords, is ex facie erroneous, seems to be for extraneous reason, but I'll challenge that, I've challenged that before the KAT. But before the sixth, if somebody is posted in my place, and this appears to be a circuitous route to ensure that my minimum tenure, which I have to.
Correct. Now that observation we can make.
Very well.
We can make an observation to that.
That's all I'm saying.
You challenge the order only of issuance of notice. Not
Yes,
stay,
that's
isn't
right.
it? Now,
At page 44.
Petitioner.
I'm told, my lord, yes.
Has challenged the order of the KAT in issuing notice without considering request for interim prayer. It's notice that the matter is posted on 6/1/2025. The only submission made by learned senior counsel appearing to the petitioner is that in light of the order of suspension still being in operation, any posting made in the interregnum to the post of the petitioner is to be made subject to orders to be passed by this court regarding the interim prayer sought for. In light of the submission.
Subject to orders passed by the KSAT, my lord.
Orders to be passed by the tribunal. In light of the submission made for the present, needless to state that any posting made would be subject to orders to be passed regarding interim prayer sought for by the petitioner as regards the order of suspension. AGA.
Notice for all
response
the
1
respondents.
to 3. Is the matter of the intervocation. You are, working there since 2019.
No, my lord, that is not the issue. But 2019 on additional charge basis, I was there, my lord, not on regular basis.
It's only an in-charge arrangement.
Yes.
Correct.
Now you are asking me kindly see, my lord, the person who is posted is a person who is not qualified to hold the post.
No, that is different. What about you?
Well, I am rendered without posting.
That will.
Lord, kindly see, my lord, whether he can hold that post when I am.
That's a different matter.
Lord, the issue is like this, my lord.
We have held.
Lord,
that,
I understand, my lord, but he is not qualified to hold that post.
That will ask the state to look into it.
Lord, by virtue of the impugned order, my lord, he's been continued, and in fact, my lord, he is working in Mysore since 2023. My lord, your lordship may kindly see, he is working as a office superintendent. Lord, on his own pay scale since 27/7/2023. Where's the question of disturbing him at this stage, my lord? That too, when he is also yet to complete his tenure.
No, no,
Lordship may kindly see the order, my lord, 27/7/2023.
You have been working since 2019.
Please, my lord.
So your tenure is still.
Tenure is not applicable. My lord, additional charge basis, my lord, on own pay scale, my lord, I was posted in 2022.
What is the, then observation is made since 2019. you have
That
been-
is wrong, my lord. Your lordship may kindly say I was posted on additional charge basis since
27
2019.
Correct, 27/11/2019.
Yes, my lord. But I was on my own pay scale, my lord. I was discharging the post, my lord, since 2022. That is, my lord, on 20.
Yes, state, what do you say?
There is no locus to make this prayer at all. He has no right to hold on to the post where he has.
That is not the
given
issue,
an
no.
additional.
That was only additional charge.
Yes.
That was an additional charge.
Additional.
And we have already
Lord,
reported.
that cannot be termed as a tenure.
Well, but what was his primary
Warden.
primary posting,
Warden.
Warden.
Which is the feeder cadre.
warden. And then in charge was,
But in charge was
Senior technical assistant.
No, extension officer.
technical, taluk extension officer.
Taluk extension officer. Ma'am.
Taluk.
Next higher cadre.
now the private respondent is now posted in his place
Please,
as Taluk extension officer.
please.
Yes.
While he was working as office superintendent.
Now, what about his position as warden? He continues,
Yes.
continues.
He will.
Huh?
Yes.
Then you continue as warden now.
Right. Can a person who is, my lord,
That
still,
will- You continue as a warden, isn't
right,
it?
I have not been given any posting. I am due for promotion as taluk extension officer.
no.
Instead of considering and
facts.
continuing my services, my lord,
Just-
can a person who is,
On facts, I want a clarification. Now, whether you continue as a warden now,
by virtue of this order, my lord, I have not been given any posting, but I am in the cadre of warden.
Tribunal has ordered that posting should be given.
Within 2 weeks.
That we will be.
Not before that, your lordship may kindly see for a moment cadre and recruitment also. Page 40, my lord.
no, about him you forget. Now
Right.
look, what is, now if you are to be given a suitable posting and they give an undertaking, then what is your grievance?
For a moment, page 90, annexure C.
Annexure?
C, page 90.
This is the order of the KAT.
No, no.
Huh.
This is the order, page 90, my lord.
90.
Now, this is the order by which the fourth respondent, who is a probationer in my lord, first division computer assistant, is being posted on his own pay scale as office superintendent, my lord, on 27/7/2023 and is posted in Mysore. As on this date, he is not qualified to hold this post also because post of office superintendent is equivalent to post of taluk extension officer. Now, when he is working in Mysore, my lord, I have been disturbed. He has been posted again to my place, my lord, to work on his own pay scale as taluk extension officer. Now, your lordship may kindly see the rules, my lord, at page 40.
That we'll ask them to look into it. We'll
Right.
ask them to look.
When
into
I have been rendered without posting, can a person who is not qualified and eligible to hold that post can be posted, my lord, disturbing me on a regular basis, my lord?
Now, when an employee points out, the state will look into it, but you can't.
My lord,
say-
but the tribunal comes to conclusion that he is qualified to hold that post.
That will ask the state to look into it.
Not when the tribunal has held it, I have no option but to challenge the validity of the order.
That we'll consider, but we are saying that you can't say that you want to continue. in
Then I cannot be rendered without posting that too to accommodate a person, my lord, who is not qualified to hold that post.
That should be done. Now in state, irrespective of the tribunal's finding, you independently evaluate. If according to you, the private respondent is not competent to hold the post, then you must take note of it, irrespective of whatever is there. If you feel, if it's contrary to cadre and recruitment rules, he can't hold the post, so be it. How are you? Now they're raising a point that you are not competent to hold the post.
We have completed, my lord. As per annexure A,
You are not competent to hold the post is what.
frankly telling, my lords,
Both of you on the same.
both are not entitled to
no.
hold that post. my lords.
Normal.
Because
Last
both
time I
are in the
raised-
feeder cadre, as per cadre and recruitment rules produced by my learned friend in this writ petition, my lords.
My lord, page 40 may kindly be seen.
Page.
40.
Now the post is of taluk extension.
Yes, my lord. Taluk extension officer and office superintendent both are in the equal cadres, my lord. Page 40. Last may kindly see the second column, my lord. Office superintendent, grade 1 and taluk extension officer. My lord, now your last may kindly come to column number 5, my lord. For promotion must have put in not less than 5 years of service in a cadre of first division assistant, warden, stenographer. In the case of stenographer, in addition to
No,
above
no,
service,
where are you reading?
my lord,
Page 40,
page 40, fifth column, my lord.
Fourth column.
taluk extension officer.
No, for
No, that
promotion.
is in the second, this one, my lord.
Hmm.
Taluk extension officer. Both office, at the top, my lord, both office superintendent is also there, my lord.
Correct. Existing method of recruitment is
Is,
by deputation.
no,
For
your
promotion.
lordship may kindly, by promotion.
That is office superintendent.
Even this one also, my lord,
Extension also.
taluk extension officer also, my lord.
Both are equivalent cadres.
Both are all, both in the equal cadre, my lord. Now, how it has to be filled up is at the next, for promotion, your lordship got it.
Yes.
For promotion, must have put in not less than 5 years of service in a cadre, in any cadre of first division assistant, warden, stenographer. In case of stenographer, in addition to above service, he must have worked as a first division assistant for not less than 1 year. A person with 5 years of service is not available. Person with not less than 3 years of service may be considered for promotion. Admittedly, my lord, the fourth respondent was appointed on 13/4/2022. 13/4/2022, he was appointed. His probation was declared on 13/4/2024. That was declared when the application was pending before the tribunal. But he has not completed 5 years of tenure. Kindly see the seniority list at page 48, my lord.
That is related to
5 years
promotion,
of
my lord.
service in cadre of first division assistant.
Yes, ma'am. 5 years of service is mandatory to be promoted either to the office superintendent or to the taluk extension officer. Now, your lordship may kindly see page 58. His name in the seniority list.
He has not completed 5 years.
5 years. And your lordship may kindly see page 58, my lord. This is the seniority list of computer assistant, my lord. First division computer assistant. It starts at page 56.
56.
Page 56, my lord. This is the first division computer assistant seniority list. The name of the fourth respondent is at serial number 50, page 58. He was appointed on 13/4/22, my lord, and his probation was declared on 6/11/24 when the application was pending. And he has not completed 5 years of tenure in the cadre of first division computer assistant.
Serial number?
Serial number 50.
So from 22.
Yes, ma'am.
He has to complete 5 years.
5 years. Now,
If he
your
has-
Not
now
necessarily.
your lordship may kindly come to the seniority list of
No,
the
just-
warden at page 49, my lord.
Just 1 minute. So you're saying only after he completes 5 years
Be eligible to hold that post.
of taluk extension.
Yes.
office.
Even office superintendent also, he is not qualified. Your lordship may kindly come to page 49. ma'am.
Yes.
This is the seniority list of my lord warden. The name of the petitioner is at serial number 5. Lord, he was appointed on 9/6/2016. And serial number 1 to 4, they have already been promoted. And he is the immediate officer who is available for promotion as taluk extension officer. Whereas, my lord, the first division account assistant, that is respondent number 4, is at serial number 50. And he is being posted in my place.
Now your promotion is still to be considered.
Yes, my lord. That is, I am the immediate available officer, my lord, for promotion as taluk extension officer. It is under consideration before the first respondent.
Yes, what do you say?
But, my lord, on the basis of seniority, there is no vested right to get the same post, my lord. Additional charge, it is additional charge. Even the fourth respondent, my lord, is holding the equivalent cadre as office superintendent grade 2, my lord, before this transfer, my lord.
Now, if it's a rule 32 posting.
Yes, it is not a rule 32.
Huh?
It is not a rule 32. He cannot be, a
On his
person can
own
be
base
posted
scale, he has
under
been
rule
posted,
32
my lords.
provided he is qualified and eligible for promotion. Otherwise, he cannot be posted under rule 32.
Petitioner should demonstrate under which law he has the right to continue in the.
That is not the issue, my lord, whether he can be posted to my place when I am qualified and eligible for that post.
No.
Pointed out,
Yes, no.
the private respondent has been illegally appointed, then that should be considered by the government. But the petitioner.
Why
cannot
government?
say
I have
that-
approached the tribunal challenging his order.
Here, there is no provision of law under he can insist that he should be continued in that. post.
Even if he gets promotion, my lord, he can't.
That doesn't
he
mean
can't
that I
say
should be rendered without posting to accommodate an ineligible person.
Posting will be.
When-
given. Otherwise,
when-
you will face contempt if posting is.
And I had the benefit of interim order throughout before the tribunal.
No, correct. But now you can't, you don't have a vested right to
No,
continue.
True, my lord.
It is not a question of vested right, my lord. I am only making a statement that a person who is ineligible to hold the post, can he be posted in my place? I was rendering me without posting.
That you have to relook.
No, we have completed probationary period, my lord. He is
Have you
entitled to.
Subsequently, my lord, after when the matter was pending before the tribunal, he has completed his probation period.
We completed earlier, my lords. The probationary period declared later, my lords.
Just Have you completed 5 years?
No.
No, not necessarily, my lords. 3 years is also enough, my lords. In the
When
same
other
law,
5 years are available, why 3 years person can be considered? But there are other persons who have completed 5 years
The person with 5 years of service, my lords, is
are not available, then it can
3
be
years, my
considered.
lords.
Vijay Kumar, ಇವತ್ತು vacation bench kirchಬೇಡಿ. Let us see. Now you just take me to that rule.
Page number 40,
Page
my
40,
lords.
my lord.
Cadre and recruitment.
Page 40.
For 40, my lords.
Kindly see the provision, my lord. For promotion,
Yes.
Last 4 lines, my
must
lords.
have put in not less than 5 years of service in any cadre, in any of the cadre of first division assistant, warden, stenographer. In case of stenographers, last,
four.
okay, please. A person with 5 years of service is not available. Then a person with 3 years can be considered. There are other senior persons who are more than 5 years available. How can he be considered, my lord?
Yes, government, you will have to look into it.
The matter is next posted on 6th.
No, that's on.
It will be 6th of January.
Where?
No, which man?
I'm sorry.
No.
No, correct. sir.
This is
Now-
the final order that has been.
No, what we are saying,
I'm sorry, my lord. I
no, correct.
confused it with another.
So what we are saying, though
But-
he may not have a vested right, but you can't bend the rules to have somebody who is not completed 5 years.
Please, I'll bring that to the notice of the office.
That observation will make. We are with you on that.
Please.
That they can't, prima facie, there's a point. But what is the finding of the tribunal on that? point?
Tribunal says that he is qualified to hold the post because he is in the lower cadre. That is the finding of the tribunal.
No, my lords.
Yes, the lordship may kindly see.
Page 25, para 7.
Para 7, my lord.
Para?
7.
7.
Yes.
Read me.
Read.
As such, I have gone through para 4 of the said judgment wherein it is observed that fourth respondent is senior to the applicant and post of office manager is 2 stages above the post of applicant. Whereas fourth respondent is in the cadre of warden, 1 post above the applicant. Hence, the above application came to be rejected.
Who's the applicant there before the tribunal?
Lord, I was the petitioner, my lord. Lord, here, kindly see, my lord, here it is pertinent to note that both fourth respondent and applicant are in the same feeder cadre, even though their status is different as warden and first division computer assistant, but both are eligible to get promotion to the post of taluk extension officer. He is not eligible, my lord. Therefore, this observation is not correct.
This you have to look into.
Because
Prima facie.
Additional.
No,
charge,
lords.
my lord.
Huh?
Additional
Whatever it
charge.
is.
In fact,
No, now,
Under the-
It is not additional OPS, my lord.
no. Now, in so far as his posting, you have to give whatever is posting commensurate to his. But definitely, the private respondent's posting
Private
Yes.
respondent, private respondent, my lords,
appears to be contrary to the C&R rules, because it says if people of 5 years are not
Not
available.
available.
So you'll have to,
whereas the
No, no.
tribunal observes that both are eligible for
Eligible
promotion.
Okay,
that's wrong.
That-
That's
not
that is probably,
Right.
my lord. Tribunal probably wanted to say that both are feeder cadres.
correct,
Both are feeder cadres to the post of,
correct. But
And-
he,
and the
but-
applicant, and the fourth respondent is also belongs to scheduled caste category, my lords.
please. ಅದಕ್ಕೂ
So
ಇದಕ್ಕೆ-
therefore, my lords, he may get his ratio in that cadre, my lord.
Huh?
He may get his ratio in that cadre, my lords, as per the seniority list, my lord.
he is the only one
Therefore,
available.
both fourth respondent and petitioner, my lords, are in the feeder cadres, my lords. No, they are entitled to get promotion as per the ratio fixed as per cadre and recruitment rules, my lords. He has no vested rights, he can't say that he will get the same post, my lords, after his promotion, my lords.
You all, but your continuance itself is doubtful.
Please, my
Your
lords.
continuance is doubtful.
Please, my lords.
Your continuance is doubtful.
No, my lords, because it is on his own pay scale, my lords, because there are no persons available to hold the post of next year cadre, my lords, in this department, my lords. Therefore, they are giving this type of arrangements, my lords.
50 people, according to him, there are at least 35 people above you.
Please, my lords.
Same seniority list, who may include for people who have done.
On the basis of roster points, my lords, I may get, my lords. Because there are many vacancies, my lords, in the extension of taluk extension officer post, my lords.
He has to complete his 5 years tenure. my lord.
Not necessary, my lords.
Not
And we have
necessary.
already reported for the duty, my lords.
That's a different matter. We'll make an observation.
Yes.
Let the state look into it. The petitioners have challenged the order of the tribunal. Now, okay, you are saying that this posting of the private respondent is impermissible even under Rule 32 unless he's qualified to
Hold the post in terms of
promotional
C&R.
post. Promotional post.
Earlier also, I was holding the same equivalent post, my lord.
That itself is illegal. That itself is illegal. That too when
Because
he was
there
on
were no-
probation. He
there
could
were-
not have been.
All government employees are staying in glass house. You can't defend any order in so far as posting and transfers. State will have to look into it. Tribunal whereby the respondent order of the tribunal in application 4856 of 24. Before the tribunal, petitioner had challenged the order at annexure E7, whereby the respondent number 4 was posted in place of the petitioner as a taluk extension officer. It is a contention of the petitioner. He has been displaced in terms of order at annexure A7 by a person who is ineligible to hold the post. Attention is drawn to the cadre and recruitment rules, copy of which is produced at annexure A3, and it is pointed out that the promotional post of taluk extension officer can be filled and eligibility for promotion would be 5 years of service in the cadre of first division assistant.
Or the warden, my lord, where
Assistant.
the petitioner is working. Or the warden also.
Taluk extension officer / warden. It's further pointed out that only exception is where a person with 5 years of service is not available. Person with not less than 3 years of service may be considered for promotion. Next. It is pointed out that the private respondent has not completed 5 years of service, and accordingly it is submitted that the posting under own pay scale or under Rule 32 posting cannot be made if the private respondent does not fulfill the eligibility for promotion. Next. Insofar as the order of the tribunal is concerned, petitioner is required to be given a posting. Nevertheless, the court cannot shut its eye to a prima facie illegality pointed out by the petitioner. If the private respondent does not fulfill eligibility for promotion, question of posting him as a taluk extension officer prima facie does not arise. State to take its stand in writing and examine the said aspect. Needless to state, if the state is of the opinion that the respondent is ineligible to hold the office of taluk extension officer, consequential orders may have to be passed. The observation of the tribunal at para 7 as regards petitioner and the private respondent being placed equally may not be correct, as the tribunal has specifically observed that the private respondent is also eligible to get promotion, while the C&R rules pointed out, referred to above, would point out to the contrary position.
Entire sentence is read, my lord. The tribunal is only saying that both are feeder cadres to the cadre of taluk extension officer.
Also say eligibility.
Are eligible to get entitlement.
He is not eligible. Prima facie.
Eligible, my lord, as per the.
Anyhow, we have asked you,
Say,
we have
when
asked you,
consideration of promotion comes, my lords, then they will look
how many
into
more,
the
how many
eligibility
more
criteria, my
months
lord.
to, how many more months to finish it? 5 years.
No, 3 years, my lord.
No, 5 years.
How can you claim for 3 years? Anyhow, we left it to you.
But what about,
AG accepts notice for the respondents.
my posting, my lord?
Respondents 1 to 3. Needless to state, posting for the petitioner requires to be given forthwith. Relist the matter on date code. Week commencing from second week.
Please.
Second week, or second day. First week biಟ್ಟು second week, next week. Of Monday ಇದೆಯಲ್ಲ, week commencing from 13th. Week commencing from 13th of January.
And you permit, take hand delivery of the order.
Yes.
Please. Dreadful.
So you want a immediate posting?
Please.
Your Lordship, this is practically round 2 of the non-compliance of the orders of this honorable court, honorable division bench, of which even Your Lordship
But
was
this
part
is a
of.
matter that has to be heard.
Please, Your Lordship, but the issue right now is, within 2 weeks, due to the urgency, the honorable division bench had said, directed them specifically to share all the documents on the basis of which they ask us to stop work. It's not even on a cancellation of a lease, whereby I could even challenge it before a tribunal, Your Lordship. They just say stop work. Your Lordship, he has been deeply affected by this. And it is, Your Lordship, it comes nowhere near the forest area. The
But we
mines
don't.
department,
This
Your Lordship,
requires- No, you have to stop. It requires their instruction. We'll have it on the reopening day. This is not a matter in which any hurried decision requires to be taken.
no hurried decision. Your
Let us
Lordship, may
see.
kindly see this honorable court's division bench's order.
It come on 6th. we'll see.
Your Lordship,
Let
might
the
I
state-
just
state
make a
complete-
mention?
No, let the
If you'll-
state complete their
If
instruction.
his Lordship in fact I'm able to refresh his Lordship's memory in this matter, Your Lordship
No,
had in
that's a
fact
different
passed
matter.
this order
That's a different
specifically.
matter, madam. Don't try to point out to individual judges. We are sitting as a bench. It's actually, it's an act of impropriety. It's an act of impropriety. You can't do that.
No,
You can't do that.
then
Can't do that.
might Your Lordship then
Bench
look at the
sits
might-
as a whole body.
might
Don't
your-
single out any judge.
No. This, Your Lordship, I am trying to state that.
I didn't have the benefit of the previous arguments.
Judge,
I didn't have the benefit
Your
of the
Lordship,
previous arguments.
Page 44.
No, that we'll see. Whether it's forest or not,
It
let the,
it is not about for,
let the state
Your
complete its
Lordship, this is
instruction.
an order
We'll
passed by
have
the
it on
mining
6th.
department,
When
not
was
the
it passed?
forest department, Your
When was the
Lordship.
order passed?
This order was passed and they handed over to us after the 13th.
When was
and
the
we-
order? What's the date of the order, madam?
Date of the order is the
30th
3011,
So you can
handed
wait.
over to us on
No, that will.
13th.
That
And
will.
13th, Your Lordship, the copy of it was received to 3 days prior to vacation.
Let us see. Let the state complete the instruction and then I'll keep it open for consideration. EG accepts notice
1 to 6. ma'am.
for the respondents 1 to 6.
Please.
Consideration of interim prayer is kept open. State to complete their instruction. This is the matter on 6th.
Please. Hold on, madam.
List after winter vacation. Yes. List after winter vacation.
This matter, my lord,
I for recall.
my lord, one
I for
submission.
recalling.
Yes, my lord.
Let
That's
it
one
come up.
submission, my lord.
No,
Let
no.
my,
this-
my lord, I filed in fresh wakalat, my lord, along with an affidavit for termination of that previous wakalat, my lord. That it may be considered. My name is not put up. My lord.
Which one?
My lord, I filed a fresh wakalat, my lord, on 29th of November, my lord. Along with a recall application and an affidavit, my lord. 29th of November.
That has to be taken on record.
Yes, my lord. The counsel who is appearing in this matter, my lords, previously, my lord, there is no instructions from him. He's not he's not conducted the matter. Said being the reason, my lord, the said RFA was being dismissed for non-prosecution, my lord. Lord, the appellant has put an letter for requesting for the status of the cases, my lord. Despite being the letter sent to him, there is no reply. Due to the inadvertence, my lord, the party has not suffered, my lord. That's my humble submission.
Correct. Now, you have obtained an NOC or he has not given an NOC?
No, my lord, he's not given an NOC.
You have filed an application.
Yeah, no, I filed an affidavit from the appellant itself, my lord. Despite, my lord, along with that application, affidavit, my lord,
Affidavit dated?
my lord, that is also on 29th of November, my lord, of 24. Along with my application for recall, my lords, I have stated in a I have attached a letter, my lords, which was sent by RPD to the counsel who was appearing previously, my lords. My lords, I was only put to the knowledge, my lords, once that execution petition notice was received to me. Until then, my lords, I was thinking matter was conducted and the stay has been granted by the Honorable Court in the RFA, my lords.
Where have you stated?
My lords, I filed in
Para 3.
Yes, my lords, yes. Along with the execution petition number is also mentioned, my lords. Only after I received that notice from the trial court, my lords, I was put to the knowledge that stay is not been given by the Honorable Court or the matter is not conducted by the previous counsel. Bill submission, my lords,
Petitioner.
trial matter is posted for on 4th, my lords.
No, now this, we will observe that your name also be shown.
Please, my lords.
Along with the existing counsel's name, let him be, because then let him check.
Please.
It's for him in case. So the remaining part will have to be considered only after vacation. Now,
My lords, the reason why I'm stressing, my lords, the mood matter is, my lords, the trial court, my lords, the execution matter has been posted on 4th of this coming month, Jan, my lords. And the court reopens only on 6th. That being the reason, my lords, I'm stressing on the.
So we'll have it on 6th.
My lords.
We'll have it on 6th because there's delay. Meanwhile, you serve the other side. Now that.
Lords, all the applications have been served to the other side.
So we'll have it on 6th. We'll have it on 6th. Let us see. Affidavit is filed.
My lords, I'm filing an IA for condemnation of the delay as well, my lords. That is the objections raised by the officer.
Affidavit is filed on 29/11/24 by the appellant, and perusal of para 5 would indicate that the petitioner, that the appellant seeks to terminate the wakalatnama issued to the earlier counsel who is on record till date. In light of the affidavit filed, office to show the name of the present counsel.
Yes, my lords. Dr. M. Sunil Shastri.
You filed a wakalat, is it?
Yes, my lords. On 29th of November, my lords.
Show the name of
Dr. M. Sunil Shastri.
Dr. M. Sunil Shastri. Full stop. Name to be shown along with the name of the earlier counsel, who is now notified regarding the intention of the appellant to engage a new counsel. Full stop. In light of the urgency made out, it lists the matter on 6th. On 6th. Other office objections to be complied with.
My lords,
file it in the office.
Please, my lords. Lords, let my condemnation of delay, my lords. I am filing an application for
File it in the registry. Now.
Please, my lords.
The appellant is permitted to file application for condonation of delay.
Yes.
Which is sought to be handed over across. Full stop.
Please, my lords.
Came to be accepted by the registry.
Yes.
Kodi. Yes.
appear for respond number
After,
5 and
after
6.
vacation,
My lordship,
after vacation, let us,
appellant, my lordship.
huh?
I appear the appellant, my lordship. The
After
appellant,
vacation, not.
The matter is most urgent because the
When
respondent
did you
number
file
five,
the appeal?
my lordship,
When did you file the appeal?
because this IA for,
23, you filed that.
my lordship, this is
Eight,
the,
9,
he's
20.
formed a layout, my lordship,
When
he's
did
selling
you
the
file?
sites.
Hello, council, please ask one only small question I'm asking. You filed the appeal when? On 8/9/23. Done?
Yes.
They don't
Alla,
move
so-
the
so
vacation benefit.
because they are formed the layout and they're selling the property, my
Correct.
lordship,
Why you
because
kept
only I
quiet
filing
for?
this appeal.
ಅಲ್ಲ 1.5 ವರ್ಷ ನೀವು ಸುಮ್ಮನಿದ್ದೀರಲ್ಲ.
ಅಲ್ಲ ಸ್ವಾಮಿ ಅವಾಗ ಇರ್ಲಿಲ್ಲ, ಈಗ ಫೈಲ್
that-
ಮಾಡ್ತಾ ಇದಾರೆ.
I'll have it on the reopening day. Take it up. List the matter on reopening day. ಕೊಡಿ.
Obliged.
Obliged.
For complaint, my lord. Disobedience of this honorable court, my lord.
List the matter.
One submission. my lord.
No, contempt matters, no, don't make submission
Okay,
during vacation.
I have given you an explanation for one of the subjections, my lord.
Hmm.
And you can exempt it.
The production of, what
No,
is
no.
that?
R 2 and 3 is not, why did you made a party, my lord?
Officer objection regarding arraying of A2 and A3.
They were also party before the petition, my lord. There is superior authority of A4, that's all. my lord. A4 is
No,
the,
but the direction is for compliance by whom?
our superior authority notice ಹೋಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ they won't bother. man.
ಅಲ್ಲಿ ಕರೆಕ್ಟ್ ಆ ತರ ಬರೆ ಎಳಿಯೋಕೆ ಕಷ್ಟ ಆಗುತ್ತೆ.
They are formal
Direction-
parties, sir.
No, no.
Let it be noticed, let it be. go to-
Direction is to
Only R4, my lord.
R4 ಅಲ್ವಾ?
Ah.
Then
R2 is and 3 is this superior authority.
you make out your case also. Relist the matter in the week commencing from 13th of January. Yes. The office objection relating to furnishing of English translation copies of documents in Kannada is kept in abeyance for the present. List the matter in the week commencing.
One submission. Notice to be issued, come accuse me.
Not in vacation, in the 13th of
10th,
January.
my lord.
No, in that week it will come. Yes, next.
Respondent number 6 in this matter. There were two rival claims.
You are not a party.
I am not a party. I filed an application for impleading. Impleading application was rejected on the very same day. Writ petition was disposed of. The very same day.
Where is that order of rejection?
That order you will also
In-
find it.
It is not, sir.
No, but they are also an impleading applicant, isn't it?
They are impleading application note.
Let us
My-
see.
My submission is,
No,
it is,
we will consider.
it is only mandamus
No,
to
let-
consider my
How you
representation.
can do that? Just look at the implication. There is some litigation right up to the apex court.
Matter is pending before the Supreme Court. There is an matter of status. quo.
Their matter is different, my
Respect
lord.
intellectual property.
That requires hearing. That requires hearing after hearing him.
Our,
Now
our,
suppose the direction is implemented, entries are changed. And
Nothing
then
survives.
Please, I'm sorry. And compensation is dispersed. Will it not have any connection with the matter? And so do we not have to hear him?
my submission is the subject matter of the property also different. If they have any grievance, my lord,
Hmm.
they can also file necessary objections before the revenue
They
authorities.
are
also.
filed here, isn't it? Why was the impleading application rejected?
Because there is subject matter of the property is
Where is the
entirely
file?
different. That has to be.
You take me to the impleading application.
My submission. At page number 170, my lord.
Yes.
Paragraph number, relevant page is 172, my lord.
No, impleading application order.
Their impleading application starts
my
at
kindly see
170,
17.
170.
Order ಎಲ್ಲಿದೆ ಅಂತ ಕೇಳ್ತಿದ್ದೀನಿ. ಅಯ್ಯೇ ಅಲ್ಲ.
No order, they have not placed, my lord.
Huh? No order is
On
passed.
the very same day, my application will be rejected, I have to work.
And
out
it
the
is not
remedies.
challenged. Even in this writ appeal also, it is not challenged.
That's why he's seeking permission to challenge that order.
Please.
Now, whether the proceeding will have an implication with respect to the apex court proceeding is a matter to be heard.
There are
May I
two,
pass on
two-
the order, please,
Kodi.
court officer.
Now,
Ma-
there's
Very
two
short
rival,
order,
there are two rival claims.
please.
One by you, one by him, isn't it? Now, which of it is correct is a matter that requires some hearing. Now, if revenue entry is to be changed and compensation disbursed, then where will the litigation?
my submission, my lord, there were two separate proceedings. Even their proceedings in respect of their property was different. And our proceedings in respect of our land was different. Even the original suit also filed by us also different, filed by them also different. And in the Supreme Court also, whatever
No,
the
correct. So
decisions.
that requires hearing. That requires hearing, isn't it?
My submission,
So
the
only take-
entire extent of land is
No, that we'll see.
161 acres.
Now you undertake not to, we'll say only compensation not to be disbursed, have it approved.
Please.
Even the entry has to be restored back, my lord. It was there earlier
That-
and subsequently it was not continued. It is the only order of the learned single judge, my lord, to restore back the
Correct,
entry in
correct.
the name of the
Now-
petitioner.
Must we not hear him, right or wrong? Now he has filed an impleading application. You can't say, go and work out your remedy. If mandamus can be issued if there's a legal duty. Suppose he is able to demonstrate that any order issued will have a bearing on the proceedings pending before the apex court. Must we not at least examine that contention?
My submission, in our matter also, in respect of our subject matter of the land also, the matter has been disposed of before the Honorable Supreme Court of India. my lord.
So let it, so we'll hear it.
And my submission, even our contention is that the subject matter of the property means the location as well as identification of the property and boundary of the property are also different. It is a vast land, 161 acres of land, my lord. Even otherwise, the revenue authorities have to identify the subject matter of the property.
Let us see. What
And
will
their
be
subject matter
the
was,
preliminary
their
instruction?
grievance was against the forest department.
Let us,
And we were not parties in their matter, nor the state,
no, now the direction is
State is a party.
forest department, not the state.
state includes forest, environmental, industry.
Means
everything.
revenue department is not a party,
Let us
only
see.
against the,
Yes,
forest.
any instructions?
and where they have sought for possession of the land.
In my suit, the state of Karnataka.
Just
deputy-
one minute.
My lord, I do not have instructions, but however, my lord, with regard to this case, I think it needs to be heard. And I'll take notice for the state, my lord.
So the only problem is, if the mandamus is implemented, the
Yes.
further direction is he will withdraw the compensation, which is the grievance of the other side. So that will have to be heard,
Yes,
whether
that
both
would be-
there's an overlap
Even
or
others-
as they claim it is different. It's a matter that requires some hearing.
Hearing.
even otherwise, we have not taken compensation which was deposited before the Honorable Karnataka, my lord. It was also, we have make submission to refund the same in favor of the Muda, my lord. We have not taken the compensation. That observation also is also there in the order, my lord. In
That
paragraph
question-
11, my lord.
That question does not arise. The moment when they came to know.
No,
that
we have not
liquid-
taken the compensation. That is what my submission.
Filed an
was.
application. My application was pending for a period of 1 year. On the day of hearing, my learned judge rejected my application, dispose of the writ petition without considering any of my application, any of my documents at all. No annexures have been referred to in the impugned order while rejecting my application. In my suit also, there is a decree against the state government. State government filed an RA before the appellate court, appeal was dismissed. Then RSA before this court, RSA was dismissed, against which the matter is pending before the Supreme Court now. An order of status quo has been granted. Both the parties to maintain status quo.
And in the
Very same survey number.
in the said matter, they have sought for
Let us
possession
see.
from the
No, let us-
Department of Forest, my lord.
Let us see, it has to be.
Our
sort-
case is entirely different.
No, it has to be sorted out. Let us. IA 1 of 24 has been filed. Seeking permission to the appellants to file the above appeal. But Mr. Chandrachud, you may also have to challenge the
Please, I will make
bill of the
necessary.
impleading application
Please.
separately.
Please.
Because there's a point, technical point
Please.
in the beginning. Above appeal against the order dated 27/11/24, passed in WP 24304 of 2021. It is a case of the said applicant that there is a dispute with respect to grants made in favor of grandfather of the appellant as well as grandfather of respondent number 6.
Please.
Full stop. It is further submitted that there is a question of identity that has to be settled. Full stop. It is also asserted that the suits for declaration filed by the applicant in the said application as well as suit filed by respondent number 6 have been decreed and the matter is pending before the apex court, wherein the question of identity of the land in question is also an issue.
No, we are not party. Their proceedings.
It is
is there.
assertion. Full stop. It is further asserted that land was utilized by MUDA for development of its project. And disbursal of compensation would require identity of property and rights to be decided conclusively. Learned counsel for the respondent number 6 would submit that the land involved are different and there is no identity as contended by the applicant in IA 1 of 24. However, noticing that any direction to effect entries would have an
There's no interim prayer sought for.
Please, madam.
There's no interim
No.
prayer.
I file application for stay.
you have filed.
Please, I number 2. ma'am.
It is in the
With regard to the stay, my lord, just one submission, the issue of compensation to be dispersed may be kept in abeyance. Because that.
no,
would be-
correct. Now, the point is he has not been heard.
Please,
So the direction is to consider effecting entries at the request of the respondent 6.
right.
Whether the direction could be issued must be done after hearing him. His case may have to be adverted.
Yes, yes.
in the view. Any direction as made by the learned single judge to effect a change in entries would have a direct nexus with the right of seeking compensation. The case of the applicant in the said IA also requires to be considered before issuing any direction as done by the learned single judge. Accordingly, matter requires consideration. IA 1 of 24 is allowed. And there would be stay of the order of the learned single judge till the next date. One sentence and learned counsel for the state request for time to take their stand in right of rival claims as made out. AG accepts notice for response 1 to 4, TP Vivekananda for 5. So and so is already representing.
Wait, madam. I may permit file objections to
Yes.
both IAs.
Respondent number 6
Six.
is at liberty to file their statement of objections to the other IAs.
My own submission is I do not know what has happened pursuant to the learned single judge's order. So status quo may be ordered, my lord, because if they have already.
27/11/24 is the order of the learned single judge.
Correct.
Within 1 month,
Nanತರ-
appeal has been
ನಂತರ ಏನ್ ಮಾಡ್ತಾರೆ ಗೊತ್ತಿಲ್ಲ.
within 1 month, appeal has been filed.
sir, I'm
No,
not on
no,
that.
Chandrachud, their, their apprehension is correct, that sometimes things move very fast.
I do not
No,
know.
She
what
doesn't
is-
know. ಅಲ್ಲ ಆಗುತ್ತಲ್ವಾ ಆಗಿಲ್ವಾ ಎಷ್ಟು ಸತಿ ಇವತ್ತು ಆರ್ಡರ್ ಆಗ್ಬಿಟ್ಟು ನಾಳೆ ಕಾಂಪನ್ಸೇಷನ್ ಡಿಸ್ಪರ್ಸ್ ಮಾಡಿಲ್ವಾ? Have you not seen? So,
I
ಹಾ.
can rest assured that nothing has been done as on today.
so you are also. Okay.
Status quo order ಇದ್ರೆ at least it
No, no,
will-
they have some
Rest
instruction.
assured, nothing has been done.
Yes.
Sir, much obliged.
Office objection may be overruled. Small objection with regard to the comparison, submission has been made.
Court fee.
Court fee paid.
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 Then, what is the other?
Other
ಒಂದೇ ಇರೋದು.
comparison ಬರಲ್ಲ ಅಂತ ಹೇಳಿ ಕೇಳಿದ್ದಾರೆ, ಅದಕ್ಕೊಂದು submission ಬರ್ದಿದ್ದೀನಿ.
ಯಾವ್ದು?
My submission may be accepted so far as the other office objection is concerned. Court fee is already paid.
ಅಲ್ಲ ಇದೇನು ಸಿಂಗಲ್ ಕೋರ್ಟ್ ಫೀ ಅವ್ರೇನು
ಇಲ್ಲ 400 ಕಟ್ಟಿದ್ದೀನಿ.
ಕೊಟ್ಟಿದ್ದೀವಿ.
Subsequently it has been paid. Annexure R3, the government advocate filed a memo along with Annexure R3. The very same document has been placed without there being an objection to the application, to the writ petition. There was no objection filed. Only the memo has been filed with Annexure
Counsel for the
R3.
appellant submits court fees paid, office to
Please.
verify. Other office objections are kept in abeyance for the present.
Date may be fixed.
This is the matter in the week commencing from 13th of January.
Please. Please.
Let it come before the regular bench.
Let's,
If at all your contention is that the order of transfer,
Yes,
there is a stay and it's not obeyed,
yes.
then so open for you to take out proceedings for contempt.
Millet, it's not a question of obeying, Millet. It's a question of interpreting the order, Millet.
Let us see, let it come
Your
before. the-
lordships, just have a look at the,
No, let it come before the regular bench, let us.
Millet, would, may I make this request, Millet? Millet, if your lordships were to,
Lords, in fact, whatever they have sought for stay, that moment order that was issued after the interim order, Lords, that was further, my Lords, on 23/12, we have issued a further corrigendum to that, my Lords. And we want to file objections to that. According to us, there was an overlap between para number 1 and 3 of the interim order passed by this honorable court. I moved the matter, my Lords, on the last working day, my Lords, on Thursday, because Friday there was no sitting of the concerned bench. Court said you take a decision, because at the end of the day, the order was passed, so that there should not be a situation, my Lords, where we are with, where sub-register officers are not manned. This is a process of guided counseling. 90 officers were involved. 51 applicants were there, my Lords. There are 30 applicants, petitioners before this court. Original applicants were 51. Out of that,
Give that corrigendum.
please,
written.
corrigendum is there, my Lords. I'll just give
Millet,
it.
may I make this
They are
request?
aware, I think they are aware of that. Now, my Lords, my submission is this. We will file our objections to that. According to us, my Lords, we have complied with the order, and that is how it is only workable. In fact, I had given an opinion. We have stated that we want to place all this before the court without their application also. How I have operated this interim order, we have given an opinion. We want to place it before the court. In fact, we want to do it on the reopening day. Now that they have moved it, my Lords, we can do it earlier also. It can be had on 6th or 7th, my Lords. 6th, I think my Lords have given date. 7th, it may be had. We can do it.
Let it come on 7.
Millet,
7th,
may-
great.
And these transfers is a nuisance.
Please. Let's-
Transfer is a nuisance.
No, this one, what we did, my Lords, was we did a process of guided counseling. My Lords, this was through counseling. They challenged the policy. We brought in a new policy, my Lords, for the purpose of guided counseling. The challenge was to the policy itself, where, my Lords, long-standing officers were sought to be shifted out insofar as the Department of Stamps and Registration as a reformative measures, because we have implemented, my Lords, anytime, anywhere registration, and then there is some issue with regard to the e-khata tagging also, that we have, my Lords, long-standing officers, we sought to do it, and it was through counseling. They challenged the counseling process. They had, my Lords, interim protection to a certain extent before the tribunal, which was given by this honorable court. Thereafter, my Lords, after hearing the matter for 2 hours, this honorable court, my Lords, in fact, granted that interim order, where, my Lords, I had placed on record the statistics of what was after the order of the tribunal, how it was given effect to. Now, my Lords, we stand by that statistics, and we will place everything on record. So therefore, it could be taken up after vacation.
There's already interim order operating.
Millet, there's
It's
an interim
operating.
order operating in our favor. It is their case, Millet. It is not to be read the way it is
That
written.
we'll see.
Millet, may I make this request? Millet?
No, but now what do we hear now? There's an interim order
But,
already.
Only, my Lord,
Hmm.
Lord, the interim order is operating, Lord,
some clarification is required. State had moved, not only one
Them
submission
place-
is.
Correct. Let them place everything on record.
It's
Nothing.
already on record.
Not
No, no, no.
They
only-
have to
You have to
place-
place.
Only one submission is not the interlocutory application now, which we have filed, is in the nature of, my lord, seeking clarification
Let
from this
them-
honorable court.
If that is-
Therefore, my lord,
No, let-
tomorrow, my lord, the very
the
bench.
matter- Let the state place it on record.
Please,
My lord,
please.
only one
This
submission.
matter on the reopening day on 7th.
7.
Let
My lord, we
additional
have
advocate
placed it on
general
record
appearing for
along
the
with the
state
IAM.
submits the certain subsequent developments.
It's
and they
already on
place it
record, my
on-
lord.
Place it on record.
Please, my lords.
Let them place it.
I will place it.
Already-
Subsequent to the IA also, there is development.
Only-
Grateful, my lords.
My lord, subject to the submission, my lord, only one
Nothing-
submission.
Nothing
Not
will
the
happen.
the bench which has granted
No,
interim
that
order.
will see. If it's required, it will go back to the same.
Same
bench.
bench.
ಅದು ನಾಳೆನೇ ಇದೆ ಅಂತ.
ಇಲ್ಲ, that is even, that bench, my
Let
lords,
the
is
state-
available on 10th.
Let the state first place it on record. If it's required, it'll go back there. only.
Please,
ಅಲ್ಲ,
grateful.
clarification ಕೇಳದಿದ್ರೆ ಅದೇ ಬೆಂಚ್ ಮುಂದೆ ಹೋಗೋದು.
That let the court decide after the state takes.
That
its
may
step.
just make this.
Yes,
ನಾಳೆ
yes.
ಬಂದ್ರೆ not, not.
Let the state place, and then
Therefore,
if it is required, we will refer it back to the same bench.
May I make this request? my lord?
Yes.
Just one request and I leave it for
Yes.
your lord. Admitted cases, we had some protection before the tribunal. There is some protection granted by your lordship. But the order that they are seeking to place reliance on and which is on record would indicate, my lords, that protection is taken away.
Let us,
Admitted cases, we had the protection
us
which
see.
was
Let-
before the tribunal.
nothing will happen. Let
Would
us
your lordships extend that protection until reopening?
interim order in operation is extended till the next day. Yes,
Grateful.
clarification ಬೇಕಾದ್ರೆ
ಅದು ನೋಡೋಣ. Then let the court, regular bench take its call.
In serial number 40, I am appearing for the petitioner.
It's a preventive detention now.
Yes, preventive detention matter.
I'll issue notice.
Lord, may I make one request? One is kindly permit us to include that writ of habeas corpus also. Only writ of certiorari is sought. I would
What has
also,
happened to the proceedings before the advisory committee?
advisory board, my lord, is not at place. That is one of the objection raised. But it is our case that even before that, we are entitled to challenge.
This is the first office objection raised regarding the maintainability of the petition.
No, but advisory committee,
Advisory committee, it is not at place, my lord.
then it's premature, isn't it?
No, premature, my lord, the Supreme Court has taken the view that even before execution also it can be challenged.
Let us,
There is,
we'll ask them to take notice and then we'll have it immediately after.
Lord,
vacation.
may I make one
Yes.
request is,
Yes.
in the prayer column, you should have also sought for a writ of habeas corpus. Kindly permit us by a oral request to include that writ also. Only we have sought for writ of certiorari.
Notes.
The-
The first office itself is that repetition is not
That
maintainable.
we'll
That
see.
is that one.
I'm
my
not
lord.
passing any order. They're making a request that there is a mistake in the prayer which they want to seek. That will allow,
Well, let them
on
allow.
merits you can.
And secondly, my lord, he is kept in Ballari jail. No doubt I have to argue on merits. In Ballari jail, my lord, he is not being given BP tablets and is put into lot of problems in that Ballari jail. Can I request for a shifting into some other jail, my lord?
No, not at this stage. Let us see. But anyhow, you take note of the
Please,
submission made.
Please.
Take note of the
let
submission
them
made.
place a memo on record to that effect.
Lord, he is asked to sleep naked. He is not being given tablets. At least let them instruct the competent officer.
For
He,
immediate vacation, my
he
lord.
says that the party says that he will not live long by this way.
Now, see, they're making some assertions,
Please, ma'am.
to the factual assertions. No, you talk to the concerned.
Please, my lords.
Obviously, they can't do that which is impermissible in law, isn't it?
Please.
So orally, you find out from them, and then you issue appropriate oral instructions. He can't now, suppose he has to be given medicine, he has to be given medicine,
Has to be.
isn't it?
Please, my
So
lords.
we don't need a court ruling on that. So you get instructions, whatever is required to be done, and what is not to be done is not to be done.
Room.
That you must do it without waiting for any order from the court.
Please, my lords.
Since it is a preventive detention, can it be taken up tomorrow, my lord, subject to what?
No, let it come on the reopening day, we'll see. Let the state complete their instruction.
Let them also place, my lord, on record because it has to be approved by the state government. We don't know whether it is approved or not. This commissioner has passed the order.
Correct, so that's why it may be premature.
No, but within 12 weeks, now 12 days, 12 days, within 12 days,
Even
they
as
have to
per
approve.
section 3 also, my lords, the commissioner has the powers to pass the order, my lords.
Correct, but it has to be approved within 12 days by the state.
Let us see
Mistake.
that you take your stand.
Please.
AGA is directed to accept notice. List the matter on 7th. AGA to take stand specifically regarding status of confirmation of order of detention by the advisory board.
Please.
As well as by the state government, because if the commissioner passes the order, it has to be approved by the state government.
And consequential and order passed by the state government in that regard. Request, oral request is made, stating that in the prayer column. by
Include the writ of habeas corpus along with the certiorari.
By oversight, relief for issuance of writ of habeas corpus has not been sought for. So in light of the oral request made, and noticing that that would be an appropriate, and noticing contentions raised in support of inclusion of prayer relating to issuance of writ of habeas corpus, petitioner is permitted to add an additional prayer at column number C relating to the prayer for issuance of writ of habeas corpus.
My counsel and record may be permitted to amend.
Yes.
To that effect.
The
With regard to the prayer.
petitioner is permitted to carry out necessary amendment insofar as such additional prayer is concerned.
Apply.
Oblige, my lords.
Appellate. The appeal
List
came
the-
to be dismissed for,
After vacation, list the matter.
problem is that, my lord,
No,
he has demolished a portion of the
let
building.
us see,
my lord.
but not now. Not now. IA for recalling is still to be considered in, not during vacation.
Now the problem is IA3 I have filed. He demolished a portion and my tenant even could not be able to stay there.
No, IA for recalling.
I understood, my
How-
lord, unless
how
it
we
is
can-
recalled it.
It has to be heard in the presence of the other side.
My lord, no, my lord, matter was not yet admitted. It was not yet admitted.
Since 22.
At the stage of non-compliance of the office objective.
Then you are only to blame. How can we do? 22 you have filed your.
I understood.
List the
My lord,
matter.
it was dismissed on 6/6/2023.
List the matter on.
Please.
7th.
Please.
Yes, next. Orders passed on
matter,
1/10/24.
The question is regarding the
No, correct. Orders
jurisdiction
passed
and
on.
limitation. I filed an application
Let it come on the
as
reopening.
contempt under
Let it come
section
on the
11 of the act.
reopening date, reopening. Relist the matter.
Now, I may be also permitted to furnish this, your lordship, in the judgment where I referred in this case, exhibit D1, that relevant point of date, I have taken borrowed money from one person, against him suit has been dismissed on the ground of the same date, 2007.
Let it,
So question of, I started a copy on the cavity.
let it come on the reopening.
Some protection may be
No, no, no. The Orders of 1/10/24.
immediately after vacation, any date,
Relist the matter
6th or 7th.
on 7th.
Open.
Yes.
PM. For the point number 3.
Yes.
Would your lordship just have a look at the impugned order, my lords? The findings would start at page number 34.
But
Lord,
before,
There are two things, my lords, that the
before my lord, my
tribunal-
learned friend would commence. Lord, both of us are working in the respective places, my lord, for the last 3 months. There was no interim order before the
No.
tribunal. Therefore, my lord,
Working.
work,
Let-
my lord,
Even
I have
if your lordship.
I have taken charge on 10/10. He has taken charge on 30/10/2024 in the transferred place. Lord, for the last almost, my lord, 3 months, I am working in the transferred place. He is working in the
No,
lord,
then-
transfer.
now, why is it moved now?
My lords, may I make this request? Tribunal dismisses my application last Wednesday. I move the bench on Thursday for end of the list. It is posted, my lords, before the vacation bench. My lords, it is not listed, I move the vacation bench. And my lords, it is posted to today since this was the next available vacation.
Correct, now it has
Let
to
may
be-
make this submission, my lords. My lords, if I don't go and report, my lords, your lordships have taken a view, my lords, that I am liable for disciplinary action. Now, my lords, please see my reporting to duty. I have made a categorical reference and said under protest subject to orders by the court.
Correct, so
My lords,
let-
just one more submission.
Hmm.
I'm assuming, my lord, your lordships are going to grant me an interim order. Even in that event, both of us are going to be working. It is not a case, my lords, where he'll be rendered without posting. My lord, would your lordships just have a look at 2 pages, my lord? I'll take your lordships. I'm not even,
No, let it come before the reopening day.
my lord, would your lordships kindly have a look at this, my
So
lord?
what is going to happen between now and the reopening day?
My lord, the point is, my lord, at every instance, if my interim order, my lord, is not considered merely because the courts were not sitting, my lord, and therefore when I move it on the next available bench, if I don't report, my lord, your lordships are aware, my lord, the recent decision in Tamil Nadu Agricultural University, where they say, my lord, if I don't report, and it was his case, my lords, that I have not reported, and therefore I'm issued with a show cause notice. That is on record. It
State
was
will
his
get-
case, my lords, that I have not reported.
Complete your instruction.
Let may I make this request, my lord. Would your lordship just have a look at the impugned order, my lords? Your lordships have, in all cases, I've produced the note sheet of the government itself, my lords. Please see what transpires, my lords, for effecting the order. I'll not take your
But-
lordships, my lords,
but-
to any other order or on the merits, my lords.
But by,
Please have page 92, my lords.
For the tribunal, there was no interim.
there
order.
was no interim
No,
order.
They said, please have a look at it. Please have a look at the
Not-
memo that was
Not-
filed.
Let
They
my learned
said-
friend say that, my lord, whether there was an interim order or not. There was no interim order.
My lords, please have a look at the
Not,
memo that was filed by my learned friend before the tribunal. My lords, your lordships will find that memo at page number 63 on the date of admission. Memo is filed saying, page 63, my lords. 64, my lords, is the CTC. The only ground, my lords, is that I have taken charge at page, he has taken charge at page 64. Now, please come to, my lords, page number 76. I'm only relying upon the documents he has produced. I'm not even taking your lordships to my documents. Page 76. He produces, my lords, a show cause notice saying, I have not gone and reported, therefore show cause notice is issued against the petitioner. But the argument before your lordships is transfer order is already implemented, therefore no interim order can be granted. My lords, may I just draw your lordship's attention, my lords, to the note sheet at page 92. Just see where the file emanates from, my lords. I'll take your lordships only to 2 things.
So merits were not in vacation bench. We'll have
My
it
lords,
on-
even otherwise, what I'm pointing out, would your lordships have a look at the impugned order? He is given a posting. He will be with the posting. I will be with the posting, my lords.
It's a list
It
of
is
matters.
not a case where either of us, my lord, will be rendered without posting if your lordships were to consider the interim prayer. my lord.
No, we'll say that. AGA accepts notice for the respondent 1 and 2. This the matter on 7th. Consideration of interim prayer is kept open.
Please. Great.
But instead of, not 7th, 8th ಬಂದ್ರೆ 7th ಗೆ ಇನ್ನೊಂದು ಹಾಕಿದ್ದಾರೆ.
ಅದೇ ಅದು ಎರಡು ಒಟ್ಟಿಗೆ ಒಂದೇ ದಿವಸ ಇರ್ಲಿ ಒಂದೇ ಮಾಡಿ ಮುಗಿಸಿ 7th, my lord. That
7th ಗೆ that sub registrar matter is listed.
in that we will stand together, in this we will oppose, my lord. Let it be on the same.
Big
Grateful.
matters. Big matters require same day only. Next.
Grateful.
case.
Yes, the defendants appeal, my lord.
No, now, limitation is still there. Isn't it?
It was filed, my lord, that's the reason.
90 days.
No, 60 days.
60 days. When does that expire? 25th
Somewhere I think in the period, during vacation it expires.
vacation. Sixty days, huh?
Yes, 60 days, here commercial appeal 60 days. ma'am.
What is the decretal amount?
The treatable notice, my lord, is 11,53,112. The question is, my lord, involved in this case.
So you deposit at least 50%.
50% of the principal amount I'll deposit because 24% interest that has been charged by the plaintiff. It has been, the finding has been given by the court below that saying that it's exorbitant. There is no such rate of interest.
So what is the principal amount?
Principal amount is 6,63,321. Adike 4,14,909. Interest has been included in the claim of the plaintiff, charging at 24%. The court said that such an interest cannot be granted.
So now how much can you pay now?
No matter if the total amount is to be 1/4, I will deposit, my lord. Otherwise, half of the amount of the principal amount. There is 6 lakhs. It comes 6,63,000. Half of the amount I will deposit.
Why can't you deposit some more amount of the principal?
I will submit, my lord. Because
Principal.
what has happened, my lord, this 24% court itself gives a finding that it is exorbitant. There is no
No,
contract.
interest will exclude.
Yes, my lord.
Now the principal amount is 6,63,000.
Lord, this is because it is a running shop, my lord. He at a time 6 lakhs is
You
difficult.
tell us 5 lakhs. Can you pay 5 lakhs? We'll give you time.
4 lakhs, my lord.
No, 4 lakhs.
Around 4 lakhs. My lord. Then some time may be granted, my lord, so that.
How much time you want?
It is 4 weeks or time quarter will deposit.
They would, the.
One submission.
Yes.
Deposited amount may be directed to deposit in bank so that it will earn interest.
Yes,
my lord.
yes.
Yes, ma'am.
Learned in light of the contentions raised. What was your defense?
Defense, my lord, there was no supply of goods at all. Because according to the plaintiff, it was supplied through a transporter as per the invoice he has raised, and the transporter was not examined at all. On the other hand, the appellant got summoned him through court and produced the records to show no such delivery has taken place to the defendant regarding that consignment at all. That has been delivered to somewhere else in the JP Nagar, whereas the defendant's place is somewhere else in Bangaleshwara. Though no such delivery has taken place, he has also given evidence before the court below, saying that he has not supplied any goods to the defendant at all.
Counsel for the petitioner has raised various contentions, including that there was no supply to the defendant, to the plaintiff.
Pardon?
No supply to the plaintiff.
Yes, no supply to the, I'm sorry, supply to the defendant. That is in the appellant hearing. It's the defendant's opinion.
So you are the.
Well, I'm the defendant in the trial court. My defense is that goods were not supplied by the plaintiff to the defendant.
They had sought for recovery from you.
He wanted to recover on the basis of the invoice.
Learned counsel for the appellant has raised various contentions, including that there was no supply to the defendant in the commercial suit. Subject to further consideration, there will be stay of the judgment and decree and so dated so and so. Subject to the appellant depositing 4 lakhs within a period of 4 weeks from
4 weeks.
today. Emergent notice to the respondents.
And such amount may kindly be ordered to be redeposited in
On
the bank.
deposit, on deposit, the amount to be kept in an interest-bearing fixed deposit.
Yes.
Okay, for the caveat respondent in this matter.
Yes.
The order is of 22nd November, my lord, more than a month. It's a final order on the IA. I don't know what necessitates moving in the vacation bench for this
We have
matter.
it on 7th.
Both sides have been heard and the order has been passed.
Submission, my lord, one small submission.
Hmm.
The goods that had been imported by the appellants herein has reached the customs and they are stuck there because of the order. The import had been done much before the order was
But
passed.
the order was passed on 22nd November.
Yes, my lords, the order was placed, order for the goods was placed before the said impugned order was passed. And the amount had already been placed, the amount around 2 crores plus. The said goods is stuck in the customs department. On top of it, my lords, every day that the said goods is there, it's been around 4 or 5 days that the goods is stuck there. Every day they have to pay damages, which amounts to more than 10,000 rupees per day. And any one day of delay also will amount to substantial cost that the appellants herein have to incur, my lords. That's the urgency why we have
We'll
moved.
put him on terms. In case,
My
in
lord,
case there is a reversal, you are liable.
Yes,
for
yes, my
costs.
lords. Yes,
You
yes,
are liable for
yes.
costs.
Yes, my lords.
my
Absolutely.
lord, the,
So just one, what we are saying, we're not entering into the merits. But what we are saying, in the event there was a reversal of the judgment and decree, obviously you will have to make good whatever costs
my lord, the, what is before this court today, my lord, is only the order on the interlocutory application.
on the,
It's an order on the interlocutory application. There's an injunction granted after hearing both sides.
correct.
The order, my lord, is to restrain them from selling goods which are passing off of my goods.
So we are not saying that, but what we are saying, that in the event that interlocutory application is reversed, order is reversed, needless to state, the party at whose instance the order is obtained has to bear the costs.
My lord, the order today, my lord, is for them to not sell any products which are an infringement of my
Suppose
rights.
it's vacated. Suppose
Then,
that
my
order-
lord, the relief would be to then go into the damages and costs
Correct.
that are.
So we are only making an observation to that effect. When interim order is passed, opposite side must always be put on terms, which nobody follows. That in the event the order is reversed, you will be liable for costs. What's there in it?
Well, he should not be permitted to sell right now.
We are not interfering.
Put me on terms that if I end up with a wrong order eventually in my side, then I will have to compensate him.
My lords.
He will be entitled for it. That's
One
legally his permission.
submission, my lords. My lords, the interim order passed here. One small, I'll get into the small merits with your permission, my lords.
We'll have it on 7th. Let it be heard.
Yes,
We'll
let
fix-
the
We'll have
uh,
it on 7th.
interim application be kept open.
Relist the matter on 7th. Interlocutory application, the interlocutory application filed
Can it be posted on 6th
Interim
itself,
relief.
my lords? Some
is kept open.
Put it beside.
List the matter on 8th.
6th itself, my lords.
8th. First
Wait for
day,
But 6th, my lords, please.
we don't know what will be the position of the
That's
board.
reopening day. Could be 7th or
Have it
8th.
on
6th to 7th itself then, my
No,
lords,
on
because
7th.
every day I'm paying
7th,
substantial amount of
7th.
money.
Like, yes.
Grateful, man.
No, let the notice go, let us.
Notice has to go to respond number 2.
You accept. So and so. Accept notice for the first respondent. For the first respondent. Records. Records. To be-
LCR may be called for. my lord.
Huh?
LCRs
Record.
may be called.
PCR to be called for forthwith.
May make one submission, my lord. There's another criminal appeal which has come up before this honorable court, that is 2327 of 2024.
This matter may be connected along with that.
2327 of
2024, my lord.
list along with criminal appeal 2327 of 24.
24.
Let us. Yes.
The notice to rest,
Huh?
another respondent notice has to be,
Emergent notice to the.
as it includes atrocity act also. my lord.
Respondent number 2.
So please, madam.
And 49.
Let
they're
it
both
come,
connected.
Huh?
But there are contempt matters pending. Contempt will be precipitated on 3rd, my lord. The personal presence of the accused officers are.
But then there is delay now.
But,
There is delay. is
it
it?
was filed in, no, as such, there is
Huh?
no statute of limitation. But it was filed in October, ma'am. The impugned order was passed in February, ma'am. Writ was filed in October,
Impugned order was passed in.
February.
uh,
My lord, now on 3rd, the contempt matter will be taken up and the personal presence of the officers is ordered. The tribunal has interfered with the impugned order of imposition of penalty, which was pursuant to a local acta inquiry on the ground that the findings are perverse. That may not be correct because the tribunal has held that PW1 has
What is the order passed in the contempt?
not personal presence has been ordered. I just pass on the
Yes.
order.
No, no, contempt before the CAT.
Yes. KT has allowed the applications. Therefore, the state is before this honorable court.
So what was the order that was challenged before the KAT?
My lord, the penalty order was challenged, which was imposed pursuant to a local acta inquiry, my lord.
What is the finding?
Penalty, my lord.
No, no, finding of the KAT.
My lord, the finding of the KAT is that the inquiry officer's finding is perverse, my lord. Lordship may see page 57, my lord, para 16. May I read, my lord? Page 57, para 16, my lord, page 57.
57. Para?
Para 16, my lord, page 57.
Page numbers don't tally. Annexure. No, you are referring to page number.
Annexure A, my lord, which is the impugned order at para 16.
Criminal case order is speaking. Annexure A is.
Criminal case, they have been acquitted, my lord. My lord, may I just say this, my lord?
No, no,
The tainted notes have been recovered.
Just 1 minute.
Please.
I'm saying your index doesn't tally with our index. So which document you are referring to?
My lord, Annexure A.
No, no, Annexure A is copy of application. So you tell us which document, we'll go to that document. You're referring to judgment or KAT order or what?
The order of the tribunal, KAT
Tribunal.
order, which is impugned in this writ petition.
219.
February it was.
No, no, page 219. was it.
Page, oh.
Annexure C.
I'm so sorry, my lord.
No,
I'll get
that's
it corrected, my lord.
That's okay. Now you take us to which paragraphs?
Para 16.
16.
16.
When we come to the last, we are much more cooler. So you can take your liberty. Page?
Page 6, my lord, the pages are not.
Internal page?
My lord, 31.
Yes.
May I read, ma'am?
Yes.
Disciplinary authority also relied upon the conversation said to have taken place between the complainant and the DGOs. In this regard, firstly, that audio cassette in which the conversation was recorded was not at all produced before the inquiry officer, though it was a specific suggestion on behalf of the DGO2 to the complainant PW1 regarding the demand of rupees 2,000 bribed by DGO2 to the complainant on 17/7/2008. That conversation is not at all recorded, but the said suggestion denied by the witness PW1. If that is so, now the burden is on the part of the disciplinary authority to prove the said conversation. PW3 investigating officer in his evidence deposed when he went to spot the clerk demanding rupees 300 and his name is not at all mentioned in the documents. PW3 is in his cross-examination on behalf of DGO2 also deposed the conversation said to have been recorded in the micro cassette was not transcribed. So also it was not sent to the opinion of the experts. Looking to this evidence of the very investigating officer himself, there is no material to show that there is a conversation recorded in the micro cassette which conversation took place between the complainant and the DGOs. Apart from that, looking to the evidence of PW3 investigating officer, wherein he admitted the suggestion that DGOs 1 and 2 are sitting in different rooms. He also deposed that apart from DGOs, there are 3 to 4 officers who were present in the office. He deposed that he has not recorded the statement of those officials and not cited them as witnesses. But looking to the evidence of PW2, MB Papanna in the cross-examination, he deposed that he has given evidence in 4 other lokaयुक्त cases when officials 3 to 4 are available in the office of the DGOs. The investigating officer ought to have recorded their statement and ought to have cited them as witnesses because they are persons who know better about the trap proceedings, which is not done by the investigating officer. Looking to the evidence which I have discussed above and coming to the inquiry officer's report, the inquiry officer conveniently avoided making reference to these relevant materials, and the inquiry officer mainly relied upon the evidence in the examination in chief and wrongly read the evidence, wrongly proceeded to record the finding that the charge against the above applicant are proved. Finding recorded by the inquiry officer in respect of the above applicants is perverse finding, and it is not in accordance with the materials placed before the inquiry officer by way of oral and documentary evidence. Hence, both the above applicants made out their case.
So what according to you?
In a inquiry, in a judicial review, okay, my lord, the tribunal interferes with the findings only on 2 grounds, my lord. Either it's a case of no evidence or it's a case of perverse findings. My lord, in this case, it is neither, my lord, because the trap has been successful. The tainted notes have been recovered from the person of the delinquent. The DGO2's pockets were also subjected to chemical tests, and it was positive, my lord. My lord,
But why the delay? Why the delay of 10 months? What we could do is maybe partially, you reinstate him, that would be subject to outcome of the proceeding.
my lord, because the inquiry, my lord, it is insofar as the standard of proof in disciplinary proceedings being preponderance of probability, my lord, it has been explained by your lordships that if there is some evidence, my lord, it should not be a case of no evidence. If there is some evidence, because the objective is to maintain discipline in the services. Therefore, my lord, it's not a case of no evidence. What the tribunal points to is that some officers who were present were not subjected to.
What is the evidence correct now, sir? What is the evidence available?
My lord, the chemical tests have both been, in respect of both the DGOs, has turned positive when their hand was subjected to chemical test. It is found that they have touched the tainted notes. And in respect of one of the DGOs, it was recovered from his pocket, and his shirt pocket was also subjected to chemical test, and it was.
Regarding that, the tribunal has not referred to.
It has, my lord, but it goes by the fact that the cassette recording was not produced, and others who were present along with the DGOs in the same office, they were not been examined. Their oral evidence has not been taken. Lord, the tribunal can interfere only if it's a case of no evidence. This is not a case of no evidence, because the objective is maintaining discipline in the services, and therefore the standard of evidence is preponderance of probability, which, as I pointed out, my lord, it has been explained to mean that there must be some evidence and not no evidence. There is certainly compelling.
Where's the reference to that evidence by the tribunal? Let us just have a look.
Please.
Page 20.
Page-
Page 20 at the
Uh,
bottom.
The evidence of PW1, the complainant, it is noticed at para 10, para 10,
Internal page.
19.
Just read, let us.
At PW1, Shri N.R. Rathod deposed in his examination in chief that he knows DGO 1 and 2. DGO 1 was working as sub-treasury officer in Malleshwaram, Bangalore, and DGO 2 was a clerk in the sub-treasury during the year 2008. He, PW1, was working as Hindi teacher in so-and-so high school, Shivajinagar, Bangalore. He had to get the arrears of 5th pay commission. Similarly, other teachers of the said school are also given arrears of 5th pay commission. The bill of all the teachers, including PW1, was prepared and sanction was obtained from BEO, Bangalore, and submitted the DGO's office prior to 16/7/2008. Then he went and met DGO2. In the respondent's office, DGO2 demanded rupees 300 from him and another rupees 300 for office superintendent and rupees 2,500 for treasury officer DGO1. And if the said amount is paid, he will issue the check. DGOs had to do this said work. On that day, DGO2 received rupees 100 as advance. He also met DGO1 and he also demanded rupees 2,500 from him. Then he went and informed Bangalore Lokaयुktha office and the police gave him tape recorder to record the voice of the DGOs. Accordingly, he went to the office of the DGOs and recorded the voice of DGOs demanding bribe amount. Then he came back to Lokaयुktha police and gave complaint against DGOs on 16/7/2008. The said complaint is exhibit P1 and his signature is P1A. He is also handed over tape recorder to Lokaयुktha police. PW1 further deposed that police secured witnesses C2 and 3 to their office and they were introduced to him and said complaint was given to the said witnesses and they went through the same and confirmed correctness from him and agreed to act as panchas. Then he produced rupees 300, 3,000.
Who produced?
The police.
Then he produced 3,000
to the police in the denomination of rupees of 5 notes of rupees 500 and 5 notes of rupees 100 to the police. And then the police smeared phenolphthalein powder.
Yes.
On the said note and given it to CW. It should be CW2 and 3. CW2 and 3. Noted the currency note numbers and CW3 kept the amount in his left side shirt pocket. Then the hands of CW3 was washed in some solution.
CW3 is the employee.
Punch witness.
Is there?
Punch witness.
CW3 is the? He must be that employee, isn't it? No, he's not the delinquent officer.
Not the delinquent officer.
Okay, he took it. Then?
Then the chemical test is applied is what is said, my lord. Then the hands of CW3 were washed in some, this is the test before the trap is conducted, my lord.
Before the trap?
Before the trap. CW3 were washed in some solution and the said solution turned pink color and the same was collected in bottle and sealed. This is to ensure that the same thing will happen to the DGOs if they accept the bribe amount. It is the contention of the presenting officer that on some points the witnesses have given contrary evidence, therefore requested the inquiry officer to treat this witness PW1 as hostile witness and permit him to cross-examine. Accordingly, permission was given to the presiding officer to cross-examine the witness, but even in the cross-examination, he denied suggestion that before the amount was seized from the DGOs, they were subjected to phenolphthalein test by washing their hands with sodium carbonate solution. He denied another suggestion that even after the police went near DGO2, his hands were first washed in sodium carbonate solution, and then the amount which was given to him was taken and seized. But he has admitted the suggestion as true that DGO2, when asked by police officer, took out the amount from his shirt pocket and produced before the police officer, and he admitted another suggestion as true that Mahazar Exhibit P7 was prepared in the office of the DGOs. But he denied the suggestion that he had given statement before the investigating officer as per P9 when cross-examination on behalf of DGO number 1, when cross-examined on behalf of DGO number 1, he admitted the suggestion that there is a government order in respect of payment of this is not relating to this one. So in the internal page 21, So it is a admitted fact that the money was recovered from the shirt pocket of the DGO number 2. This is the primary basis on which the inquiry officer holds that the charges are proved.
Just take us to the inquiry report.
Please. Lord, it is at annexure A11.
Yes.
Here it is page 216.
A11.
A11.
Just take us to that relevant.
Para 25, my lord.
Para?
25. Internal page is 13, my lord. It's in it's darkened on the right hand corner, page 13, internal page 13. Para 25.
This has only 8 pages, 7 pages. Kannada.
Annexure A11 dated 27/7/2020, my lord. Says.
Dated?
27/7/2020.
No, but where is the order? The pages don't tally. The A11 is the order of 25/4/23.
My lords perhaps have the first writ petition. I take your lordships to the second.
344. Second one.
Second one. 34718.
Next go to next file. What page you say?
Well, the inquiry report starts at page 216, my lord, annexure A11.
But the employees are different in both. One in 34403 is Mallikarjunappa and 34718 it is Nagarajaya.
This is it says both the DGOs, my lord, here in the subject part of the inquiry report. At the very first page of the inquiry report, my lord, page 216, if it is annexure A11, my lord.
But the report is different to both, isn't it?
Joint inquiry. It's a joint inquiry, my lord. The subject says, may I read, my lord, the departmental inquiry against.
Page?
Page 216 is annexure A11, my lord, inquiry report. I'm so sorry, my lord.
Okay, so just take us to which paragraph?
Para 25, my lord.
Para 20?
25 at internal page 13. It starts with the words on the other hand.
Yes.
On the other, may I read, my lord? On the other hand, complainant being vigilantly approaching the official superiors of DGO, even in earlier circumstance, about the payment of premature bill must have left sufficient caution upon the DGOs. Further, the power of withholding the payment must have led to DGOs for this indulgence. Because when amount is offered to DGO 2, he should not have pocketed it. And DGO had every occasion to return it, even when offered voluntarily, but it was not done so. In addition to the complainant, shadow witness corroborated the allegations. The said corroboration is consistent with the evidence led in the criminal trial. Complainant obviously has the concern of encashing the bills, whereas the shadow witness had no reason, and his interest evidence, the shadow witness has consistently stated about the conduct of the DGOs. Therefore, the evidence of complainant when corroborated, it is up to the DGOs to rebut it. But it's not a case of no evidence, my lord. That is my respectful submission.
But he's
Because
been
it is consistently held by your lordships that only in 2 instances the evidence will be reconsidered, my lord. When there is it's a case of no evidence or it's a case of perverse finding. It is not neither. The tribunal says it's a perverse finding because the cassette recording was not produced.
in the criminal proceedings, in the proceeding before the criminal court, was there any reference to the trap aspect? What is the finding?
My lord, there they have succeeded, my lord. Criminal
Correct,
proceeding.
that may be so,
Please.
but what is the finding regarding that trap incident?
But in but it starts at page 293, my lord, annexure A16.
Page?
Page 293, my lord, annexure A16. But as a preliminary, if I may submit, my lord, before going through the judgment in the by the special court, my lord, but the only situation where the judgment in a criminal proceeding will have a bearing on disciplinary proceedings is when the acquittal is honorable. Here the witnesses
we are-
have turned
no, we are-
hostile.
we are-
Therefore, both being separate proceedings, my
We
lord,
agree with you. But we are saying now one of
I'll
the-
take your lordships to the relevant.
Only insofar as that incident
Trap.
of trap
Yes.
and the staining,
Yes.
let us see what is the finding.
Page 323, my lord, if the annexure is at the right page.
Page 320.
323, internal page is 31, my lord.
Yes.
The bottom of the page has para 36 starts at the bottom.
Ah.
Coming to the acceptance of tainted notes by the accused in exhibit P1, it is mentioned that on 16/7/2008, your lordship has it. On 16/7/2008, clerk demanded rupees 300 for himself and rupees 300 for superintendent, and accused number 1 demanded 2,500 and he gave rupees 100 to the clerk. Therefore, to the clerk rupees 200 balance was to be paid, and for accused number 1 rupees 2,500 was to be paid by PW1 as illegal gratification. The complainant has produced rupees 3,000 before the investigating officer on 16/7/2008. Carrying of rupees 3,000 by PW1 itself is doubtful in view of this evidence. PW1 was carrying tainted notes of rupees 3,000 with him at the time of trap. PW2 was also with him as a shadow witness. Name of the clerk to whom balance rupees 2,000 was to be paid is not mentioned in exhibit P1. At the time of trap, PW1 is said to have paid rupees 2,000 to accused number 2, whose name does not appear in exhibit P1. In other evidence, PW1, it is not stated as to why rupees 2,000 was paid to accused number 2. If accused number 2 was the clerk to whom rupees 200 was payable and he demanded rupees 2,000 at the time of trap, it was natural for PW1 to raise objection for new demand of rupees 2,000 instead of rupees 200 and argue with him and to state the same in his evidence. PW1 has stated that other teachers had not authorized him to get the bill sanctioned and to pay bribe on their behalf. Then complainant paying rupees 3,100 to accused only for clearing his bill would be doubtful. PW2, he stated that accused number 2 informed PW1 that bill cannot be cleared as is premature and advice not received. Under such circumstances, accused number 2 accepting rupees 2,000 as illegal gratification does not get established by the evidence led before the court. Even in respect of accused number 1, PW1 has stated that accused number 1 had demanded rupees 2,500 and out of that he gave tainted notes of rupees 1,000 and it was received by accused number 1 in his right hand and then kept on the table. Though it is clearly stated that accused number 1 had received the amount in the right hand and then kept it on the right side of his table, the hand wash of both hands of accused number 1 in sodium carbonate solution has turned to pink color as per the evidence given before this court. This will raise doubt about the genuineness of the hand wash of both the accused as stated in trap measure. on considering all these aspects, the acceptance of tainted amount by accused number 1 and 2 is not true. Well, the criminal court goes on the putting that because amounts which were demanded and which were actually given, they are different. Therefore, it raises a reasonable doubt. So benefit of doubt is given in criminal proceedings.
So court also observes that there was no, his money was not cleared as on that date. His claim.
Arrears of salary
Ah.
was the payment of arrears.
No, wait.
Clearing the bill for payment of arrears of salary was the basis for the demanding the legal.
No, page 28
Please.
of the judgment of the
The inquiry report, madam. Page 28.
criminal court.
Yes,
Page 28
Please.
of the judgment.
please.
In the middle, there is one observation. When Treasury advice was sent by BEO office only on 17/7/2008, accused demanding bribe amount for clearing bill on 16/7 is doubtful.
But the fact remains that the tainted notes were recovered from them, which puts the burden on them to, they have to explain, my lord, when a trap is laid, my lord, and they are caught with the tainted amounts, the investigating officer immediately asks him, how did he receive that amount?
Both
There is
have, both have retired.
No, one was compulsorily retired. He was still in service. The treasury officer
Yes,
imposed with a penalty subsequent to his retirement of withholding 50% of his pension.
What is the age of the other person? He's also attained now.
He's my lord, Mallikarjunappa is the retired officer. As on 2024, it is mentioned in the tribunal's order, he is aged 69, my lord.
Correct. So this Nagarajaya, as on date, what's his age? He still has service, isn't it?
Nagarajaya is 56. As on 2023, he was 56, my lord, as per the tribunal's order in the cost title.
No, only once we take note of it, it will.
But he is guessing that it could be around 48. 48 or 49.
Once, only problem is, once we consider any interim relief, then we don't know when it will come back.
But,
it requires some early disposal. These matters will lie in cold storage. By then, he's 70 years, he'll already be.
Lord, before the tribunal, so the punishments were imposed, I am told, my lord, there was no stay before the tribunal.
No stay.
That is what I'm submitting that on instruction.
There was no interim relief before the tribunal.
But can I confirm that post lunch? Because he is a little doubtful.
Find out. Telephonically, let them find out. Let them find out telephonically. We want to wash our hands off. We want to wash our hands from the list today. So I don't want to come back after lunch. The one pass to a matter, I'll take it. Pass over.
Please.
Just find out.
Please.
what's his style?
Yes. But suspend, the state must secure records alone.
We have punished all the parties to them. They had appeared and lost that year.
Reopening day.
One indulgence minutes.
Yes, reopening, day. Yes.
Indulgence. Minutes, this is pertaining. Mention for tomorrow, urgent matter minutes, because this home buyers minutes who are not guarantors or borrowers minutes. Minutes, they had filed a suit. Their suit is rejected on the bar of section 34 of the surface here. Now minutes in teeth of an order of interim protection granted in a writ minutes, our homes are locked. The banker minutes has gone ahead minutes and locked the premises. That is why minutes, though the appeal was filed, there was an order of interim stay in the writ minutes. Minutes, minutes, there was no urgency to move that. The order has come out on 4/12. 4/12. There was no, now minutes we are on streets. The problem minutes is if there is no indulgence shown minutes from past Saturday minutes,
No,
this
no.
action has been taken.
Action by the Surface Act.
Minutes, it is an action taken by the bank.
Under
the
Surface
Surface
Act.
In enforcing a 14 order minutes.
Let it
And I
be.
was not a borrower minutes, not a
Reopening.
banker. I am a home buyer minutes, and my
Reopening.
suit is rejected.
Reopening day.
Minutes,
Reopening day. Yes, next.
very well. Minutes, if there could be an indulgence for tomorrow minutes,
No.
if there is no urgency minutes, it may be mentioned minutes that there may be
Reopening
cost
day.
input.
Reopening day. Yes.
Minutes, the families are on streets. Very well.
So for the appellant, I spoke to the council who are, they are not able to give a date for visitation, my lord.
My lord, we have given a date, my lord, we have given a date for fourth,
Lord,
my
the
lord.
trial court order says there are 2 days
No,
from,
just we have heard it. They're only on visitation, right?
only on visitation. my lord.
Right.
The trial court order only permits me to have weekly 2 visitations, my lord.
Hmm.
Now they're telling on Saturday I can have exercise my first visitation in this entire week. And that also they're telling at a time frame from 11 to 12 or something like that.
Just one. Yes, so what are your instructions, madam?
My lord, the only problem is that they are in Mumbai, they're coming back only on second evening. Third, the child has not gone to school till 10 years, they have not admitted to school also. So we got an interview call for the school on third. So that is the reason we have said on fourth, my lord.
Can exercise.
No, for the present, on fourth, you exercise your right. Now you can't, on fourth, what time?
My lord, from 10:30 to 1:30.
Ah.
Fourth and fifth, my lord. Two.
Fifth is a Sunday, my lord, and mediation Sunday is not working, my lord. And we have apprehension on visiting other than any other places. Maybe next week we will permit, ma'am.
On fourth, we will provide
Yes, yes.
visitation right.
Yes, ma'am. Yes.
Then, we'll
Yes, madam.
discuss it on a date. On that day, let the court consider.
Please,
Yes,
my lord, I'm
yes, ma'am.
also submitting a memo, my lord.
Hmm.
This is a memo just to bring on note that the consent, this temporary arrangement is to bring on the fact that the appellants are not consenting for the custody only as a matter of temporary arrangement.
Absolutely. Now, the matter is highly contested.
Please, ma'am.
It requires hearing
Please.
because of objections, cross objection, etc.
Please, ma'am. My lord, also I've sought for communication to the minor child through telephonic call or through.
You fourth, you meet it, we'll have it, we'll fix a date immediately.
Please, ma'am.
After vacation, short date, we'll give it. On
Please.
that day, we'll say that this arrangement made is only till the next date.
Please,
Then you make out your case.
please, ma'am. May be permitted for a video call with the minor child today.
Fourth, you do it, sir. On fourth, you exercise your right. And then immediate court reopens on sixth.
But last 1 week, there are no information as to whereabouts of the child, what is happening.
Child is with,
They moved the child out of the custody of the
child is with,
jurisdiction.
Child is with the parents, ma'am.
just 1 minute, madam, just 1 minute.
Yes, sir.
Child is with whom? Parents.
I admit that the child,
So fourth will give you opportunity on fourth.
but the trial court judgment also in fact says that there is the child may be permitted to have interaction through telephonic call and through video call.
That's there in the trial.
That's there in the trial court.
Just point out.
But
If there is an order, we will not come in the way of that.
My lord, page number, ink page, 121 of the judgment, my lord. 121 ink page, my lord. The petition filed by the petitioners in GNW 9 of 2020 is declared to declare petitioners as guardians and grant permanent custody of Rian Agarwal is hereby dismissed. However, liberty is given to the petitioners in GNW 9 of 2020 to visit the child twice a week without any disturbance, disturbing the educational activities of the ward, and also make video calls every day.
Now,
For the last 8 days,
this direction you will have to comply, madam. That
Yes,
we-
yes, my lord. We are ready to comply, my lord. That the only problem is that on 4th, we will have permit visitation and we will permit video calls. There is no issue for us in permitting video calls.
So we will only say visitation rights and interaction in terms of order in GNWC to be adhered to.
Please,
to be adhered to, we'll record 4th.
please.
And then any other date, then after 4th, now this order was passed when?
12, 11/24.
From 12th November, there's no visitation, is it?
My lord, the child was in custody with the appellant till 22nd of this month, my lord. On 22nd, they come for visitation, my lord, once the appeal was filed, they filed execution. They come for visitation, snatch the child in a car, throw the child in a car and run away, my lord. This is how they've got the custody.
Who has taken the child?
My lord, irrespective, the trial court order says the custody should be handed over in accordance with law. If the parents are only abducting the child, my lord, this is with all bona fides, we go for visitation and they snatch the child, my lord. What is the effect of the order? They themselves have filed for execution. What happens to the execution, my lord? Is there no meaning for law when all these kind of acts have been committed by the respondents? Now, all the way they've gone to Mumbai and they're sitting in Mumbai and telling that they're not in Bangalore, my lord. This is all just to avoid the proceedings or to summon the child or keep the child present before the court or make them available to the appellants.
No, let us see. There's no incorrect. No, this requires hearing. In so far as the interim relief and nature of interim relief is concerned, same requires hearing in light of the nature of contest and peculiar facts of the present case. Noticed that the order in GNWC 4 of 20 and 9 of 20 has made certain observations regarding to visitation rights, as also making of video calls. Full stop. However, this arrangement is post implementation of the order, and admittedly, order comes into effect 1 week after the period of limitation. Full stop. In the case of the respondents, that the child which was in their custody.
Child was in my custody.
Correct.
Case of the appellant.
Case of the appellant, that the child which was in their custody has been taken away contrary to the direction of the court. Full stop. For the full stop. However, it is submitted that without that, as the court is as on date not considering the request for interim prayer, without prejudice to the contentions raised in the present appeal, the court may at least work out an arrangement till the next date, insofar as visitation and interaction of the child with the appellants. Taking note of the direction passed regarding visitation and interaction in the order impugned, it is clarified that interaction through video calls in terms of the order may be permitted till the next date as ordered. Insofar as visitation rights, on 4th, learned counsel for the respondent submits that the child and parents are in Mumbai, and necessary arrangement would be made as regards visitation rights. Taking note of said submission, the respondent, to ensure that child is brought to Bangalore and made available for visitation by the appellants between 10:30 to 1:30 on 4th at the Bangalore Mediation Center. It will be open, is it?
The council has also inquired, my lord. It will be.
Center, full stop. It is clarified that this interim arrangement is done only till the next date.
Please.
And it's open for both sides to make out their case on merits and seek for appropriate reliefs before the regular bench. Matter is not being dealt with in detail in light of paucity of time before the, in light of the present bench being a vacation bench. Full stop. Relist the matter on 7th, we'll have it, please. On 7th. It will be uploaded.
Please.
Memo filed by the appellant is taken on record. We'll club both the matters.
Yes, ma'am. Please.
16 to be clubbed with 17 to be clubbed with 16.
Please.
And order passed.
May we permitted to comply with the office objection.
The appellant is permitted to comply with the office objection. So the only resolution for this dispute is to try and sit across.
Please.
It's a peculiar fact situation. So let the court hear it at length and see what is to be.
Please.
Order has been complied, man. As per prayer one.
Not yet, Lordship. What has happened is
No, but what is that?
admission
Order, my lord.
given to the petitioner, Lordship, but KEA is yet to update its portal and direction to the college and
That we'll make, that will observe. Good, sir. You must start positively. Yes, they have complied, but what is more required, we'll do that.
please, Lordship.
So now they've given, they've extended time for reporting to 30th.
30th.
Isn't it?
Yes,
And you have been given admission
Yes,
in
Lordship.
Vide Institute of Medical Science.
Please,
We'll
Lordship.
take that on record and direct them to give consequential directions to whom? To
Lordship,
the college?
Yes, Lordship.
Ah,
College and the college has to admit the student.
that will, they'll issue appropriate direction to the college. And then we close it.
Please.
There are procedures prescribed in case
Yes,
of
Lord.
default. We'll make an observation.
Yes, Lordship. That was the submission I was making because KEA is having a list of procedures to be followed and even in the college they have to follow.
Memo filed along with a copy of admission order. Full stop. Land counsel to the petitioner submits that though the order indicates admission is complete and extended time for admission, however, consequential directions may be issued to the college in order to ensure that the admission order is implemented. Full stop. In light of the subsequent event, petition is disposed of not calling for any further adjudication. Respondent KEA issue appropriate direction to the college authorities in terms of the admission order produced along with the memo.
Lordship, we may be given liberty.
In the event any further direction is necessary, the appellant is at liberty to seek for such appropriate direction by filing necessary application. Accordingly, petition is disposed.
Submission, my lord. NK Ramesh may be shown, my lord.
Office to show the name of learned counsel NK Ramesh as appearing for respondents.
One, my lord.
One.
2 is why. 2 is why he called.
Notice to the institution is waived for the present, is waived in light of the stand of the KEA. Court fee you have to pay.
It has been paid in the morning.
Counsel for the petitioner submits that court fee is paid, office to verify. You have paid it.
Yes, Lord.
This can be. Memo filed. Enclosing copy of receipt for having paid court fee. No mistake, no. Yes.
In serial number 40, my lords, we requested the pleader that I may be permitted to supply the prescription medication, which is being refused, saying that unless a state medical practitioner examines him and furnishes medication, that cannot be considered. Maybe I request a direction, my lords, that I may be permitted to take prescription medication only for existing ailments.
You just call him,
Please.
We'll wait. We'll wait.
Informed that there was a stay, but it was never, they never sought the implementation of the stay order. So therefore, he has remained out of service.
So many years.
So many years.
He
He has not sought for reinstatement subject to the, pursuant to the stay order. And provisional pension is being paid. So in fact, he is getting more than 50% of the pay. So punishment, provisional pension would not entitle him to DCRG and this one. Pension will be paid based on the last paid run. So 50% is not withhold.
It's being paid.
Provisional pension is being paid. And the other person has not sought reinstatement pursuant to this stay order.
Light of the contentions raised, there will be stay of order of the KT till the next date. It's made clear that as the matter is being considered in the vacation bench, we leave it open for the appellant, for the petitioner to make out case before the regular bench for extension of such interim order.
Grateful.
All contentions are kept open. The only problem is
We will try to serve them at the earliest, my lord, so that they can also be represented on the next.
Emergent notice to the respondents. Only
Can
problem
we
is,
take hand?
petitioner.
We will try to serve them before the next date of hearing.
Permitted to take out notice by way of hand summons.
Great.
Relist the matter in date. Date 15th.
Grateful.
Only reason, once you stay, we don't know when the matter will come. That's the only thing while granting.
We will make an attempt to serve them immediately so that they will be represented on the next date of hearing if they have a good case for vacating of stay that can be pressed. Grateful.